Wait, please, my lord. My lord, to the consent of the respondents, I beg to mention item number 20. They have filed an additional affidavit, I'm told, but it is not on record. So, my lord, may fix it on Friday, my lord. Till then, the affidavit may come on record.
Uh, Mr. A. Borua, learned counsel for the petitioner has submitted that who has filed affidavit?
The Agriculture Department,
Okay.
respondent 5.
The respondent number 5 has filed an additional affidavit.
Yes.
Additional affidavit in opposition. In that case, and the state additional affidavit in opposition is not tagged with the case record. He has thus wait for listing of the case on with the state additional affidavit in opposition of the respondent number 5 on. At least that
17th, I'm obliged. Item number 20.
Yes.
I'll have to leave out earlier, doctor, for some medical issues.
Oh.
Maybe fix
On the
any
prayer
other
of Mr. L.J. Mojumdar, learned counsel for the petition, the case is passed over for that. Mr. Your State Counsel, Mr. H. Sharma, learned additional senior government for the state.
Maybe. For listing, my lord.
Bench 4, bench 5.
I bench 5.
What is admission?
Admission.
Right.
15, my lord.
Huh?
15.
Court martial. What is the subject matter?
Felling down of trees,
Huh?
and art cutting matter. Forest, related
Okay.
to forest.
Also, with regard to item number 9,
9.
inadvertently a document has been crept in the writ petition we have filed.
9.
9, your lordship.
Yeah.
With that regard, inadvertently a document has been annexed. My lord, we may be allowed to correct it.
Document and be annexed means
My lord, a document has been crept in without our knowledge, my lord. Some other document.
you want to change it or
Yes,
what?
your lordship. We want to change it. Page number 71, annexure 11, your lordship.
Page number?
71, annexure 11. My lord, the show cause that has been issued to us has been replaced by some other show cause.
Mr. S. Gautam,
S. Gautam, your lordship.
learned counsel for the petitioner has submitted that an incorrect document has been annexed to the writ petition and the same needs to be replaced. So, he has thus wait for lifting of the case after
Lordship,
In order
next
to-
week, I'll just
in order to
I think
make necessary correction.
they have to file an IA amendment.
Mr. H. Kamal and additional public, sorry, senior government advocate. Assam. Yes, present. Please the case after.
Lordship, in that regard, IA need not be required, my lord.
We don't know. This correction we don't know. High Court, you consult High Court rule.
But it may be to possibly matter for timing and not the big total appearance for it.
Otherwise, on the last occasion, time was granted whether GST tribunal is functional or not. My lord, I also inquired, it is not functional. And there is no interim relief, my lord. Payment we have already made the payment. Only notice may be issued.
Let Mr. Story come. Right.
May I please your lordships, the matter relates to non-compliance of the Honorable High Court Order 19/6/2023, passed in WPC number 6224 of 2022. The judgment is in page number 10, lordship.
Third, MS
S. Boru,
as board. Clerk, Council Potter. The present application is referred leading non-compliance of the direction in an order dated 19/6/2023, passed in execution WPC number 624/2022. So submitted ever a copy of the order dated 20. Copies of the order were duly submitted before the respondents. So submission notice return is for it. The applicant will take the export of the notice by the city upon the response. By the city within few of the police.
Yes.
Nine.
Lordship, at page 91, paragraph 8 is the operative part of the order, Lordship. We were directed to file a representation that we filed on 19/2/2024. Thereafter, the opposite party was directed to give us a hearing so that we can inspect the revenue records on 18/3/2024. That has not been done. And a speaking order had to be passed after 45 days from the date of receipt of the representation. Lordship, page 91, para 8. Lordship's order only, very categorically stated. Lord.
Third, Mr. MP. Correct. For applicant. The present contempt is preferred alleging non-compliance of the direction in an order dated 12/2022, passed in the execution
6620 of 2023.
620/2023. Ever that a copy of the order dated 12 was duly furnished before was duly
Representation?
submitted before the respondent of
Page 90.
respondent. How many respondents
Only one, Lord.
submitted before the sole respondent on 19/2/2024?
Yes.
Issue notice regarding
Lordship, the next matter also the same order will do.
same.
Date is also same. 19/2. Operative part, your Lordship will find at 84. The that order judgments operative part, page 84. And the representation, your Lordship,
2024, WBC 6621/2021,
23, Lordship. 6621 of 23. WP.
2023. Copy submitted on 19.
My dear.
May it please your lordship. Lordship, the imperial order is at page 59.
High Court Counsel
Mr. G. Bashar.
D. Butcher. Inform.
Oh.
You take up.
May I please your lord?
Yes.
My lord, basically, my lord, we are, my lord, against the, my lord, that in action of the Deputy Commissioner, my lord, in consideration of a my lord representation submitted for cancellation of a patta, my lord. That has been my lord obtained. My lord, that was my lord from annual. It was earlier my lord annual patta. It has been converted into the my lord periodic patta, my lord, without following the due procedures of law, my lord. And in which name my lord the patta has been issued. He himself, my lord, sworn an affidavit that he has not, my lord, communicated with the circle officers in any manner. And my lord, the and the settlement, my lord,
So who are you? Who are you?
my lord, I am the my lord, I am
You cannot go for cancellation of patta of anybody. Who are you? Why?
only-
How
my
your
lord,
rights are?
my lord, I am in the possession of the land, my lord. And I have made
Huh?
my lord, only my limited prayer is that, my lord, my representation may be, my lord, considered, an inquiry may be conducted and appropriate order may be passed. That is only my limited prayer.
Yes, Mr. Sharma. Break instruction. Whether yes, he is in season of the matter or not.
Lord.
If it is received or not. Who
Receipt
is
or
that?
receipt, my lord. Page on, my lord, on
Your
page 40, my lord.
40. There is nothing which
My lord,
indicates receipt.
my lord, they have received, my lord. Even, my lord, I personally with my lord, with the petitioner has submitted before the
Let
tribunal.
them verify because
My
there
lord,
is
my lord.
nothing.
My lord, let
on
them
record.
verify.
It is the
Page 40,
Econo type copy.
46.
Page 40.
Page 40, whether it's the type copy of page.
You know, type copy or
Not
this
like
is type copy.
representation.
Where is the original then?
Original one for Econ type copy. Page 40, A22 type copy. Econ edition.
Page 40 is type copy.
Not,
I also think so, but you said that this is
this is the
No, there is no signature also.
yes.
representation that has
Page 45.
Page
my lord,
45.
perhaps it is wrongfully, my lord. Let them verify, my lord.
Let them verify. This is not the way to
I apologize
file
for
a writ petition.
my lord. That I apologize
We're
for the
sorry.
Let
inconvenience.
him
Perhaps,
place the original one, Lord, because it's the type copy. Lord.
my lord, I have personally, my
No
lord, submitted.
signature, not personally.
My lord, because my lord, I apologize for the inconvenience.
Ah,
Inadvertently,
you are in
perhaps,
a read code.
not my lord, my lord. Well, perhaps my clerk has made this inadvertent mistake.
That plea cannot be taken by a lawyer that my clerk has done this thing, that
My lord,
thing.
tomorrow, my lord,
Before filing, one has to check the writ petition.
my lord, my lord, can be
It
possible
is up
tomorrow?
to you.
Well, tomorrow I may be allowed to rectify this.
It is up to you. Go through. I am not observing anything. It is for registry to decide on the prayer of the Vikira, the case pass over for that thing. You take this appropriate measure
Now, can it be on Wednesday, my lord?
when it is the case.
Well, but-
My lord, refreshment room in the refreshment room in the Rongia railway station. There is just crux of the matter, my lord, just latest position, my lord. What has happened, my lord? There was a policy under that 20 of 2017. That policy was regarding catering policy. That policy didn't have any renewal. But thereafter, my lord, that policy was in February 2017. November 2017, my lord, Railway has entered into a fresh lease agreement, my lord. That is there at page 50.
Page?
Page 50. '51, my lord, 51. 51. My lord, on the second page, lordship will see at the paragraph number 7 regarding the tenure of the particular tripartite agreement. Page 115.
Yes.
Now, my lord, at page, I'll directly take your lordship to page 18, 118. Tenure, my lord, it has not been mentioned. And now, my lord, 118, lordship will see, my lord will see that till November 2023, my dues have been complied with, all the license fees. 9 November 2023. My lord, thereafter, in the meantime, what has happened, there was a series of litigation before his honorable court also regarding floating of a particular tender in the year 2021. Thereafter, my lord, finally, your lordship will see there is I'm directly taking to the final order of the division bench, honorable division bench of this honorable court at page, no, 106, my lord. Last paragraph, 106. In view of the above submission and noted here.
106.
Yes, 106, my lord. It says, my lord, in view of the above submission noted here and above, without recording separate reasons for this writ appeal.
No, read from 105. However,
Yes, yeah. However, at that stage, Mr. J.N. Sahiwala, learned senior counsel, appearing for a respondent, submitted that the present writ petition is running one replacement room along with
the appellant means you.
Yes, me. Aladhar Kavita. Now, my lord, finally,
Submitted a press tender was initiated only in respect of replacement room at Romania railway station. The same has been fined. Same has been fined. Therefore, the state order does not cover the case of the replacement of the appellant be allowed to deny the
finally it says, my lord, it was in regard to the NIT.
Who is the NIT?
NIT is that page, my lord, at page 119. Impugn notice. NIT is, impugn NIT is at 66, no? 66, my lord. Page 66.
That was in 2021.
Yes, it was a subject matter of a earlier writ application, my lord, writ petition, and I have shown that order that was assailing particular order of this honorable single bench before the division bench. The matter of the NIT was left open because the earlier writ petition was infructuous because of another writ petition. My lord, there are a series of writ petition. So ultimately, my lord, this NIT issue was kept open, my lord. Liberty was there, my lord. So now what has happened, my lord? Finally, 119 is our termination letter. My lord, may I just point out one thing?
Yes.
Yes. My lord, read petition 431. Read petition 4138 was for petitioner was aggrieved because area issues, my lord, regarding they have quoted some higher area without any reason.
So ultimately,
Yes, yes.
division bench says that this is the subject matter of the tender process. Petitioner will be at liberty.
Yes, yes,
Liberty is granted.
Yes.
You sought liberty.
yes,
I think page
yes,
106.
yes, I have found that, madam.
Let us see. You were the appellant there.
I am the appellant.
It was submitted on behalf of the respondent that the tender process was initiated and finalized. Then the counsel for the appellant submitted that appellant may be allowed to challenge the decision of the respondent authorities in initiating the tender process. Then observation was made that this
Yes.
order would not cover the case of the writ appellant so far as the refreshment room is concerned.
That is
The
my room.
appellant is left at liberty to take recourse of the suitable remedy for ventilating his grievance regarding the fresh tender. That is what
Yes. Now,
we are
my lord,
limited to.
now 119 is the impugned communication, my lord.
Now, what is this speaking order? 119.
Yes, 119 is the vacation notice, my lord.
No, no. It is a consequential order. There is a speaking order.
Yes, yes.
6/4/2023. Second paragraph.
6/4/2023. Yes.
Hmm.
As per railway division speaking order, dated 6/4/23, vendors cannot continue with stalls and they are requested to participate in the
So
open.
there is a general order,
Yes.
and this is a consequential notice.
Here, my lord, therefore, I place before your lordship at the very instant, my lord, that what has happened, my lord, this particular order was in view of 2017 policy, which says, my lord, there shall be no renewal. But my renewal or my press that agreement is after that particular policy, my lord. So 2017 beyond, it is beyond 2017 policy. My lord, they have only agreed. My authorities have, my lord, because after 2017, there cannot be renewal, but press agreement can be, my lord, that can be done. So
Agreement on what basis?
for renewal, not for renewal, for again putting the vendor to the place, my lord. So what that agreement I have shown, my lord, that is
What is this speaking order, Mr. Sayola?
My lord, that is railway, my lord, because it is the Rongia station is coming under Amrit Bharat station. My lord, Amrit Bharat station, they are renovating everything, my lord, so they are closing everything, my lord.
No, page 119.
Yes.
This is under challenge. One.
My lord,
Second paragraph.
yes,
As per Rongia Division speaking order,
yes, my lord, that is railway, that is not
dated
higher-
6/4/2023.
Yes.
erstwhile vendor,
Yes,
not one.
All.
Cannot continue with erstwhile catering stalls,
yes,
and they are requested to participate in future open tenders for catering stalls in railway stations over Rongia Division.
Yes.
Hence, all units were closed and vacated with immediate effect.
my lord.
So this speaking order has been passed. Thereafter, he is one of the vendors.
He is not that, my lord, he is represent room. So far he is concerned.
Whatever it is addressed to him,
Yes, this is addressed to him because they are
is
reconstructing.
it this speaking order is part of the record?
no, my lord. We have not been.
Because there is a decision,
Yes, we do not have knowledge about it.
and this is consequential one.
But on my only line of difference, my lord, is this particular omnibus decision might have been taken on behalf of 2017 policy.
I don't know.
Yes, that is we are also not aware of, my lord.
My lord, here what
Our
happened
agreement,
in 2021 tender, we have finalized it. Well, he is paying about 14,000 and odd only per month. But we got, my lord, 11 lakh 13,000 and odd, my lord, per year. But he refused to vacate, my lord, in spite of the division bench order. And he did not challenge that, my lord, settlement. If your lordship may just see, my lord, this is the settlement. We have
What took you, that was 106.
106, my lord. 106.
Uh,
So he has not
106.
challenged it. This settlement.
It was
And
passed
he-
in which date?
Hello?
13th.
Yes.
What took you 1 year to challenge?
Oh, yes, they have not challenged it. Well,
What
lord,
took you? Tell me.
Yes, we have come.
Is there any explanation there?
My lord, the new
You took the liberty from the division.
my lord, this order, impugned order, my lord, it was passed on in 29/4.
That is a different thing.
Yes.
But the tender NIT was in existence since November 2020.
Correct, my lord. That is there, my lord.
And you took the liberty in March 2023 to challenge. So what took you so long
My
to
lord,
challenge in May
I am
when
al-
you received the
Yes.
vacation order? You know it is coming
My lord, honestly,
because submission was made that same has been finalized.
Yeah.
Yes.
Tender process has been finalized. You know very well in March 2023. And you took the liberty from the division bench to challenge the tender process. Right. See? To may be allowed to challenge the tender decision of the respondent authorities in initiating the tender process for the refreshment room at Rongia Police Railway Station by availing the appropriate remedy. Right? This
Yeah.
is a submission.
yes,
Thereafter, liberty was granted. The appellant is left at liberty to take recourse to the suitable remedy for ventilating his grievances regarding the fresh tender process undertaken by the respondents in respect of the refreshment room at Rongia Police Station. So, what took you so long to challenge
my lord,
the tender process
I-
initiated in 2020?
I have only one line answer, my lord, to this. They were accepting thereafter also. They were accepting the license.
That does not mean
My lord, that is what we thought, my lord, because
that, no.
it's a, my lord.
After taking liberty from a division bench,
Yes.
pursuing litigations a number of times,
Yes.
that cannot be a ground. Have you explained why you have not? Let us see.
My lord, paragraph
Just
20, my lord.
acceptance of license fee.
Yes.
May not be a proper ground.
My lord, what they have done, they have gradually increased the rent also. We,
That is a
we had the
different-
understanding, my lord, said they have, my lord, because I will just, at para number 20, my lord, page 18. That the petitioner begs to state that after passing the order dated is passed in the writ appeal number 89 of 2000 till date, the petitioner has been running the refreshment room as on date. It is to be stated that the IRCTC revised the license fee of the refreshment room from time to time. Later dated 27/2000 reflected that the annual license fee is 19,356 per annum. Again, the license fee was revised and later dated 17 issued by the IRCT shows that the annual license has been enhanced to 24,220. The petitioner has paid the entire license fee to IRCT till November 2023 as per the letter dated 17/1/2022.
So when was this NIT
21.
21 was under challenge at any earlier point of time?
Yes.
No.
It was under challenge.
Then why you took liberty?
Yes. That I'm
Why you took liberty before the division bench to challenge the NIT in 2020?
my lord, just for that I have to chronologically, I'll just have to say, my lord, 4318 was an application, writ application, my lord, wherein I assailed certain area orders.
That is
Yes,
different thing.
and in that there was a stay of the particular notices at that point of time, and we are allowed to run. In the meantime, my lord, this NIT was floated. In the meantime of that particular order of this honorable court, then we assailed that particular NIT through another writ. Here, when 438 was disposed of, then honorable single bench disposed the other writ application where we challenged the NIT.
Where is
Yes,
challenge the NIT?
say to be infractuous.
Where is the
Yes.
where you have challenge?
Yeah. It was second order. 70 problem. 70. Huh? 99, my lord. At 100 is the order. Your lordship will be. Now, my lord, another point may I,
Let me
Point-
understand first.
yeah.
Now come to page 97. I think that is number of repetition. Number of repetitions
Yes,
decided.
yes.
There are 19.
18 and 19, yeah.
19.
19.
This court would also take note of the fact that by virtue of the interim order, the petitioner, you are one of them, I think,
Yes.
are continuing to vent irrespective of the fact that presently they have not renewed their time. It is the opinion of this court and accordingly clarified that the right of the petitioner to vent is dependent upon the licenses given by the railway administration, right? And since the renewal or allotment, the petitioners would have no right to vent. Accordingly, the railway administration would be within their rights to take appropriate decision as per the existing policy,
Yes.
right?
Yes.
With the above observation and direction, all the repetitions stands this.
Yes.
Page 97. Page 97.
Yes.
Then page 100, I think,
100.
taking into account that while a separate judgment and order dated so and so passed in 4138. 4138 is by whom? I think you?
48, yes, by me.
Okay. The said interim order has been vacated and the state railway authorities have been permitted to proceed in accordance with the existing catering policy. Right?
Yes.
The instant repetition has become infructuous and accordingly dismissed.
Yeah.
Interim order stands vacated. Right?
Yes.
Then
Against
That
418,
division bench.
we went to the division bench. Then, my lord,
So,
102.
Liberty was granted to the railway authorities by the single bench to take appropriate decision as
Before
per
that,
their
I point one thing, my lord.
policy.
That particular judgment, that judgment at 106, my lord, at the second line, my lord, my senior friend, my lord, has submitted on that occasion. It is also submitted that fresh tender process was initiated only in respect of the
I am
refreshment.
trying to find out.
Yes.
You prefer two repetitions.
Yes.
One has been decided in a batch of repetition.
Yes.
There, the interim orders were vacated.
Yes.
And the right of renewal is not there. It is observed. Right of renewal is not there.
Correct.
That is may not be directly applicable to you. But at the same time, railway authorities have been granted the liberty to take appropriate decision as per the existing catering.
Yes.
Right?
Right.
Then on that basis, your second repetition
Was dismissed. Was
held to be infractuous.
infractuous. Correct.
But at the same time, that continues, that railway can decide.
Yes.
As per the existing catering policy.
Catering policy.
Right?
So,
And matter went to the division.
division bench.
There you got another liberty that you may challenge the tender,
But the fresh one, my lord. But the fresh one.
not based on
Yes.
finalize.
It said, my lord, it is also submitted that the fresh tender process was initiated. We do not have any idea about that, my lord.
How can we?
Yes, my lord. Now only question is that my,
How can we?
yes, my lord. Now
no.
my
How can it be, Mr. 2021?
yes,
Phase tender process
and this is 23.
has been finalized.
That they will be able to answer, my lord, whether fresh tender is floated or the earlier
At
tender is.
least I am clear in my understanding.
Yeah.
I don't know. I need not ask for clear clarification.
My lord, in the writ appeal, it was submitted from the from the other side, my lord, that fresh tender is initiated. So, my lord, we have to get some. We didn't have any knowledge.
Now the basic question is this: ultimately, railway has taken a decision by speaking order 6 for 2000.
That speaking order may not be.
Who produces it? I don't know.
No, my lord.
Served or
No,
not, it
we
is
have not.
exactly served along with actually this notice. Because it flows from this vacation notice, flows from the speaking order. This is a consequential action. Mean the reasoning
Omnibus.
is to be included in the speaking order. This is a
Yeah,
consequential order. Right? Railway has been granted to take appropriate decision as per the existing catering.
My lord.
There is an existence of a tripartite agreement also
Yes.
with the petitioner. Then in the division bench, he sought a liberty to challenge a tender process. Right? Now he has challenged the tender process here. And also this order. Now, everything is dependent on this, what the railway authority has taken. What is the existing policy if they have correctly
Yes.
proceeded with the terms
My lord,
and
we do
conditions
not.
of the catering policy,
Yes.
then this may be right. And if that is wrong, then this may be wrong.
Yes.
That is the only issue. So there has to be speaking order. But there is a tripartite agreement also.
After that,
Which is-
That is handed over to IRCTC, madam. Railway authorities has handed over these things to IRCTC. That is the tripartite.
no, not
Because
that.
earlier railway was
Tripartite. We are also a party to it, my lord.
party.
2017.
Conspicuously, there is no period mentioned.
Yes.
No, but tender it was period. Tender it was period. Original tender there was a period.
But
And now
no, in a tripartite agreement, it is of 2017 perhaps.
17.
There is no period mentioned.
No period mentioned, but 17 policy, my lord, which has come after, there is no thing.
But policy was
In-
before
Earlier.
tripartite agreement.
But anyway, my lord, now the question is this tender was finalized, and as per the tender, my lord, we have to renovate the, my lord,
Right. Mr. Gupta, you produced the speaking order. Monday?
My lord, may I have a copy
Monday.
of it? Copy of that, my lord. if it-
If he produces before the court, he will be entitled. You have not received it.
He
But it is found that you have already been served, then there will be different conflict.
My lord, another aspect of the matter, my lord. 13th, they are asking me to vacate. Otherwise, they will vacate forcefully, my
So
lord.
what is Monday? What is the date?
Monday. Monday is the 13th.
Monday, 30th.
Monday. Heard Mr. T. H. Hazarika, Learning Council for the petitioner.
My lord, I have an apprehension, my lord. In the morning, they may take over, my lord.
Mr. Okay.
Yes.
Where will we stay otherwise?
I do not need a stay, my lord, that much only. I do not need stay at this stage, my lord.
I
That
have
would be enough.
already
my lord.
till the notice or whatever is decided, don't take any. Don't take high-handed action. Mr. H. Gupta, Learned Central Government Council for Development number 1 and 5. Mr. G. N. Sahavan, Learned Senior Council,
We are appearing for
It is
3,
said
4,
by-
and 7.
Mr. N. Anik Singh for Development number 2, 3, and 4.
3, 4, 7.
2.
3, 4, and 7.
So Indian Railway Catering and Tourism Development,
Yes, we get that.
2, 3, and 4.
I'm sorry, madam. 3 and 4. 2, 3 and
2, 3, and 4. Poster. Mr. Gupta, Learned Central Council. Shall produce. The speaking order is 109, not second paragraph. Number C stroke 470 stroke RNY stroke CATG stroke 2019 stroke MISC stroke in bracket part 11 dated 6/4/2023 passed by the Rongia Division on Monday. This is the case.
We'll get the copy that day on Monday. I will give.
Okay,
Obliged,
before moving the repetition, you provide a copy to him.
Yes.
Mr. Goyal is on legs, my lord, for number 15. Or my lord, I take it up on the next week, my lord.
Next week.
Next week.
H.O.D. is available. Okay, the prayer of Mr. H.O.D.
H.O.D.
Please the case. Planning Council for the petition. Please the case. On Monday?
No, my lord,
On the
15th or 17th.
Friday.
Right, 17th. Obliged.
Planning Council applicant. It's all applicant. They are up. Read that. Up. But it is accordingly passed over for that. For instance. Okay. Okay.
May it please your lordship.
Yes. Fraction.
Yes, lordship.
Rounding off.
Rounding off.
Yes, what is settled law?
Lordship.
What is settled law?
Oh, lordship, I have got.
Oh, Pawan Kumar Tiwari.
Yes, lordship. Paragraph 6, lordship. May I read, lordship?
Okay, I'm aware of. Yes. Heard Mr. D.J. Kapil. Learned Council for the petitioner. and Mr. G. Bushaw, Alliance Pending Council, GHC, for all the response. The petitioner is the the father of the petition, late investor Dr. died in harness on
9-7 Lordship.
Hmm?
9-7 Lordship.
where it is mentioned.
That's page number 21 Lordship, first annexure. That left side column bottom, second line.
Not in a synopsis. Where is it? Page? Okay, 9/7/2016. When he was serving as a lower division assistant in the establishment of the response number 3. Also, after the demise of late Investor Dr. his wife
Rupam.
submitted an application before the respondents seeking compassionate on appointment, seeking appointment on compassionate ground. So subsequently, the petitioner submitted an application for her appointment on compassionate ground. The state application was processed. In terms of the scheme, quote unquote, scheme for compassionate appointment for the Guwahati High Court, principal seat and district court establishment of Assam, unquote, notified by the notification dated 3/1/2007. Where is 5%?
5% is a clause 18 Lordship, page 42 Lordship. Page 42 Lordship. 15, 16, 17, clause 17 Lordship, bottom.
As per clause Roman 7 of the scheme, compassionate appointment can be made up to a maximum of 5% of the total strength of a cadre at the time of recruitment in any grade Roman 3, not above the cadre of LDA, in bracket, direct recruitment is 40%, or grade 4, within bracket, direct recruitment post. The case of the petitioner, where is that impugn observation?
Impugn observation on page 59 Lordship. Lordship, if I may.
The petitioner is aggrieved by the impugn by an impugn order dated 20/09/2023, passed by the respondent number 2, whereby the application of the petitioner for appointment on compassionate ground has been rejected due to unavailability of vacant post in the cadre of grade 3 and grade 4 in the establishment of the respondent number 3 as per clause Roman 17 of the scheme. Full stop. Whereas Mr. Phil and counsel for the petitioner has contended that the respondent number 2 has erred in holding a view that as per holding a view that 5% of the sanctioned stake rank in grade Roman 4 cadre within bracket 17 posts in the establishment of the respondent number 3 filled up on compassionate ground would come to less than 1 post, and as such, none can be filled up on compassionate ground. The contention of Mr. Kapil is that if 5% of 17 posts comes to above 0.5, then the same shall be rounded off to the next higher integer, that is 1. And as such, the ground of rejection of the petitioner's application for compassionate appointment is illegal and arbitrary. It should not return it in other date.
My lord, the petitioner is the daughter of the deceased employee.
Daughter
Her mother's case was first considered. Thereafter, she appeared.
But
On
She enters, but your ground is not there.
my lord,
You take this plea and at the time of
my lord,
filing.
Yes.
I have already observed.
Yes, my lord, the father had applied first.
I have
It
observed.
was rejected, but then the daughter applied.
The question is that is his challenge is this.
my lord,
Here the only
only
observation.
the order
Mr.
doesn't-
Boishal, I am standing out, the
Yes,
GST has submitted that initially, the wife of the deceased employee submitted an application for completion appointment, and the said application was rejected. So it was only thereafter, the petitioner had submitted the application seeking appointment on completion ground, and the said application has been rejected by the impugn order dated 2009.
Lordship. Lordship, I have made an interim prayer. Also.
Returnable influence. So,
I have an interim prayer also, Lordship. At least one post in the establishment. Otherwise, if the posts are again filled up by advertisement, then there are to my
posts are vacant or not?
there are 4 posts vacant to my information, Lordship. At present.
Yes, Mr.
subject to outcome.
No, if the filled up, then how can you replace?
I have confirmed information that 4 posts are vacant at present.
Let me take instruction of it.
Okay, Monday, Wednesday. In the above, Mr. Kapil, learned counsel for the petitioner has submitted that at present, 4 number of posts in grade 4 in the establishment of the respondent number 3 are vacant. So, Mr. Boishal, sending us a GST, submitted that he may be allowed to take action on the said on the aspect of vacancy as sought for by
Fine.
Problem.
But in item 13, I have prepared the affidavit and vetting has been done, and I am awaiting the signed copy of the affidavit in item 13. In item 12, I need some time. I could not prepare it. 3 weeks time, if given both,
Both.
I can file.
Mr.
I'm sorry.
M. Chaudhary. Both the case. Both the
Both
case.
the-
Identical.
Part that petitioners and the each of each of the up and has sought for further time to file counter affidavit in both the repeating.
Both the
The prayer is allowed if the case after chief file it, then you may recommend.
Yes.
All right. Forest royalty.
Yes, forest royalty.
IA or repeat?
Both. Lord.
Both can be heard.
Yes.
Can be heard.
Yes, Lord.
Then Tuesday we'll hear both. Tuesday
Yes,
will be free
Okay.
because there are 40-50 cases.
Lord.
Tuesday.
In stay vacating follow in admin.
Oh, we'll decide the repetition. Why stay vacating? We don't go into the business of stay vacating.
Look.
If the repetition has merit or the respondent has merit, right?
Look.
At least if I understand it correct.
Lord.
Okay, RM Das. Oh, Mr. P. Hazarika for the petition. And RM Das, the understanding of the water resource department for the response. Place the cases on
The interim order that
interim or partial.
available.
I have received the instructions in this matter, but some time for filing affidavit.
Mr.
K. Uddin.
Yeudin, Planning Council for the petitioner, and Mr. Itkedas, the for the response number 1 in
Yes, sir. 1 and 2.
Mr. Das. That's big one. And is granted. How much?
3 weeks time.
Takes time to file counter affidavit on behalf of the and
My lord, date may be
the price allowed. Please the case of
Lord.
Did it come? I could get.
The matter relates to the acquiring of the proposed acquiring of the land on under Mala project. And we have been started with office. We have filed objection and they have filed the affidavit. We have given reply also. But they have not heard us. They have not asked us to put off. And our prayer is that the present value may be consideration. Considering the
No,
land.
it is direct part.
Yes.
Your lands have been taken over.
Not yet. Notice has been given. But
Position.
they have proposed that they wanted to fill up
You have
it
been
by.
paid.
Yes.
You have been
Not
paid the
taken,
money.
No, nothing.
No.
No.
Did you sign anything?
No, not yet.
Not yet signed.
Not yet.
Then if you are not agreeable to the offer made, then
My lord,
everything
they are
goes-
giving the agreement.
Yes, Mr. Taluja.
21.
What is this direct mala? What is
Assam Mala.
Assam mala?
Assam Mala is not binding on.
Direct
Direct
purchase.
purchase.
If they do not want to accept the money,
Yes.
it goes.
Yes. That is the-
We want, let them come for negotiation. But,
No, we are not negotiating table.
but in national
If
interest.
if they offer 5 lakh, if you want 10 lakh, then better stop under this negotiation method. And High
But,
Court cannot be used as a negotiating table.
But,
Then their only alternative is to go for compulsory acquisition.
They have not done it.
That-
But in that.
It is agreement. Agreement cannot be forceful agreement. Yes, please. Now tell me what is the stage of this direct purchase?
Direct purchase, that is under the Assam Mala scheme.
Assam Mala scheme. Now they want how much?
They are claiming 10 lakhs 50,000.
10,000. And you are offering?
3 lakhs as because according to us, it falls in a different area.
So parties are not at item
Agreeable.
agreement. They are at disagreement.
In that case, Lordship, under the Land and Revenue Regulation, they will have to follow.
2013 Act
Section
or
26
national-
must follow. Section 26. Section 26 of the right of the compensation.
Oh, those will not come in.
27(1).
That is their problem. And though they are saying that it's different place, but the same place.
No, no, we are not here.
Categories of
It is
land is same.
simple,
Those are-
a very simple thing. If they agree, disagree, stop. This is the view of the tentative view of the court. We are not to be the master for negotiation.
Your
This
lordship
suit
has
is not
given
for
judgment.
not
Under
for
that-
negotiation.
Under the Assam Mala scheme,
High Court in the read proceeding is not to be used as a medium for
Lordship,
negotiation between two parties. That is all.
Lordship.
My lord, your lordship has already decided one case, my lord, page 66.
Based
66, my lord.
which
Read
repeat?
petition.
Which repeat? Two repeats.
Yes, yes.
Which one you have?
4303, my lord.
430.
4303. Page 66. 65. 60.
That is representation.
That also we have given. They have not taken into consideration.
No, question is they, if they do not agree.
My lord, half of the 3 lakhs and 10 lakhs.
No, no, no. The question is not that. If you do not agree
Yes, my
to the rates offered by them,
Yes.
it is simple. You reject their offer. Very simple. This High Court is not to be used as a medium
for
for
direction.
negotiation. Representation, they are not acting. So you make a statement before them, we are not agreeable to the rate. That's all.
In that case,
We are not here to decide
Yes.
the rate. We are not experts.
And in
They are
and
not
we will
following the
continue a matter
provision of
of
law
bail.
also, my lord.
in the Assam Mala, that under that scheme in 4.17, it
This is your
specifically
writ
mentioned.
petition.
Yes, please.
This is your writ petition. Fakir Ahmed Borbhaiya.
No, it is other.
Moinuddin is him, Lord, the 430.
From the same area.
No, no. Question is not- Now come to page 69 of that order, paragraph 7. First, second, third, fourth, 10 times. As per step 17, in the event of any owner refusing to sell the land or any of the owners has objected or not interested with a direct purchase through negotiation, the respective land may be acquired through land acquisition process of the Assam Right to Fair Compensation and Transparency Rule 2015.
Yes.
And there the question was that they submitted representation.
We
And
also
the
submitted.
petition was disposed of. Pass a speaking order on it.
They are not doing it. There is
You
a,
are not a petitioner here.
there is a land.
They are
part-
not, the petitioners therein are different.
There is a committee also in the district level.
Lordship,
no.
according to them, they have also filed representation, the same direction. They are taking.
That we are praying for.
No, when we take up petitions on the same subject time and again, some more knowledge is gathered.
Very true.
Why should we be relegated to a medium of negotiation? Yes, simple, clear and simple. Trades are not an agreement with the parties. We are not here. We are not here as a low catalog or MSCD tribunal.
There is a
MSCD tribunal, right?
district level committee is
Claims
there
tribunal. We are not here claims
in
tribunal.
this respect to decide.
No, Mr. Biswas, I am asking a query straight that whether a writ should be used for the purpose of negotiation.
No, that cannot. We have come with our grievance, my lord. That our voices have not been heard. my
So you make a clear application, we are not ready to accept it. End of the matter.
lord. Our representation may be disposed of. My
Now, I have said that as and when more and more restrictions come, this court also gathers knowledge.
the court is already full of knowledge, my lord.
So why sense has prevailed now that this court is not to be used as a medium for negotiation? Why should we direct them to dispose
The
of it?
problem is that they will acquire my land. Now they will go to take steps of acquiring my land. They will not
I
take
have
it.
asked you very first point of time. Did you take any money? No.
No.
Whether your lands have been
Acquired,
taken,
not.
acquired, not taken possession of. So what is that? Nothing.
No, they have come to fill up.
Under the right
Part, my-
to fair compensation
Which I have
2013 Act,
objected.
they have to follow.
Yes.
Now they have to follow that. They have to follow the rules.
They're not
The
following.
money
Specifically
You'll
mentioned in the
get-
gazette notification.
will be much higher. They have been trying to fix it on zonal valuation rate.
Lordship,
They are not giving it. The journal believe it 2021. Now 24, my lord. Or 23. But
So
they have
you wait
covered
for the
21.
land acquisition process, you will get 25 lakhs.
No, I'm not asking for 25 lakh, my lord.
That
The
will be law.
Actual value, my lord.
Whatever will be fixed. But question is,
Present valuation may be considered, my lord, by them.
why should we direct? Why
No,
should we
uh,
direct?
Not that, my lord.
This is a case of offer and acceptance. Where is the role of the court? It is a direct purchase method. They will offer, they will make an offer, you will convey your acceptance or refusal. What is the role of the court?
My lord, may
Tell me.
I bring to your lordship notice section 26, my lord, for a moment, my lord.
26 of what?
That is right to fair compensation.
Not required. That does not come into play.
It will come into play there after the acquisition.
In the acquisition process.
Lot.
Here is a offer and acceptance. Simple. Take your call. Next Friday, we'll give a final consideration to both the reports. Take your call. I'm not giving final consideration, but next Friday or Monday, I'll give final consideration.
Next week, Malad. We
Next
will have a
Friday or
next Friday.
maybe. Clearings exchange.
Yes,
Clearings
sir.
exchange.
Yes. In 4303. biddings
That
are
will cover.
Yes,
Yes.
Okay. Heard Mr. S.T. Victos, learned counsel for the petitioner, and Mr. K. Sharma,
Sure.
learned anybody revenue, P.R. Mohanto, learned standing counsel revenue and disaster management department, H. Sharma, learned education government advocate for the state. So, the learned counsel for the parties have submitted that bidding submitted. Please the case on file.
Sure.
एक मत पूछो कागज में लगे कुछ हमारे ना हाँ कितने काम की
My lord, here, my lord, I have received the instruction, my lord. She is trying to file affidavit. And my lord, he is not entitled to get any interim order, my lord, because he is not entitled. After 1/2/2005, GPF will not be given.
My lord, we have filed an additional affidavit with lot of documents showing that thousands of employees regularized during the period of 2005 has received the old pension scheme and the provident fund, my lord. So, Lord, kindly see the additional affidavit. my lord.
Okay, let them file affidavit whatever. If you have lost something, it will be compensated. Is it not?
Yeah,
It is not a case of filling our vacancy or something like that.
No, nothing.
What is the
On-
case? It was initially appointed.
Lord, my lord. He was
Petitioner
regularized on
therefore
1/2/2005, my. And the,
again promoted to the post of
it is, my lord,
LDA.
additional affidavit based
1 minute. Let me understand case first. It is work at the park. If
affidavit is
them for
already
activated, okay, thereby it is on or after 1 as per circular we define it with after okay, beyond yes, what is additional affidavit?
My lord, additional affidavit page, my lord, you are also kindly see the page 63. The petitioner has done the RTI application to the defined department. It is irrigation department, Assam Guwahati, my lord. So here, my lord, the question with reference to the above, I am
Which one? Which page?
page 63, my lord. Additional affidavit.
Additional.
The it is Department of Irrigation from Guwahati, my lord. The with reference to the subject, I am to furnish BDOT replies to your petition. Petition mentioned under reference on the basis of the materials available on record. Point number 4. Here are 7,764 64 number of grade 4 post
of Master Rule and the 559 9 days my lord number of workers, and also has been regularized from 22/7/2005. They were working from 1493 and they were regularized in the 22/7/2005, my lord. My petition was regularized 1/12/2005, my lord. The above mentioned regulations of master workers and the service employee have been brought under the old pension scheme and also GPF account. The same has been transferred to the superintending engineer and different department they were transferred, my lord. So secondly, my lord, it is under from the irrigation department, Jorhat. With reference to the subject cited above, I have the honor to submit here with the reply sought by you RTI Act 2005 for favor of the kind information and necessary action, my lord. The reply next page is 65 that the application of Vipul Kumar, the son of Horace Kumar, it is the question A, how many temporary contractual and master role workers were regularized during the period of 1/2/2005 to 31/12/2005 as per declaration made on 15/8/2005 by the Chief Minister? The answer, all the 149 employees were regularized from 1/2/2005 to 31/12/2005 as per declaration. B, in respect of those employees, what type of question the pension rule, CPF, NPS was applicable? Answer, in case of those regularized employees, CPF account was applicable. How many regularized employees were retired and whether they received the pension or not? Out of total regularized of 15 employees retired and other received pension. Here it is. Next on my left, page 67. It is from irrigation department in India. With reference to the subject cited above, I have the honor to submit here with the RTI report under provisions of RTI Act 7. You may file an appeal petition before the executive engineer, Tinsukia division. It will file before the next page, my lord. Next page 68. The question number A, service of how many temporary master
Now, if the
roles and
GPF is not
contractual
applicable,
employees
what
were
is
regularized?
applicable? If the GPF is not applicable, what is the basic benefit under the GPF?
Lordship in the CPF account, accountant general located the CPF account. CPF account.
Accountant
That
general.
subscription is deposited in the account of the account. That is running by the accountant. There is office memorandum of the finance department. They have joined after 1st February 2005. Lordship, if their CPF amount is deducted, Lordship, then government will give him with interest. Lordship. No, but they were employed in the 1993, my lord. 2005 already regularized. And my employee, my petitioner, he joined in 98. He was regularized in 1/5/2005, my lord, or 1/12/2005, my lord. So as those employees, thousands of employees are getting the benefit of provident fund, and pension, the petitioner is also entitled. So
His GPF account was running.
Yeah.
That was running till
that
2023.
was open, my lord.
Huh? Now come to page 46. Whether this shifting is correct or not, but your observation that no interest will be paid, or interest will be paid only up to the month of 31st December 2011.
46.
No claim or of interest on GPF accumulated money beyond 31/12/2011 is admissible to the subscriber. You enjoyed the money.
There's a notification of the finance. Protective we have.
Why he should be deprived? Who will compensate that?
Government will give it, he will get the interest for depositing the account.
2011?
Yes.
From 2011?
Up to 2000.
No, no. I'm simple arithmetic. I have parked my money in a bank. Right? For 10 years, up to say, from 2000 to 2011. It continued up to 2020. Simple arithmetic. Simple common sense. I'm not an expert like accountant general. But suddenly in 2023, accountant general says that your money which has been kept deposited, or whatever was accumulated till 2011 will be refunded back with interest. But whatever money was deposited after 2011 till 2020, say for example, we enjoyed the money, but we will not pay any interest. You take your money. This is a simple understanding of page 46. Shifting of GPF or to other SIM is another. But simple understanding of page 46 is this. You clarify who will compensate the petitioner. No interest. Suppose he has deposited 10 lakhs from 2011 to 2020. He has been deprived from utilizing that money, from getting any benefit out of the money because money has been parked with the accountant general for 9 years, 10 lakh. Now, suddenly in 2020, you are saying, I will not pay any interest. Read, Mr. Taludar. Who will do it? He has to explain. Right or wrong, shifting is a policy. See, no claim of interest on GPF accumulated money beyond 2011 is admissible to the subscriber. Who will clarify? Tell me.
No, I one.
We don't know. We don't know. Your answer should be there. Specifically, who will pay the money?
Yes, sir.
Simple common sense.
But it's a equity. He's entitled.
Who will pay? Court is to be sure. Shifting, that is a policy decision. That from GPF to this. But in the process, you have taken another decision that 2011 onwards, whatever money has been deposited, no claim for it, no interest. This is prima facie wrong. Amount.
Yes, deposited that.
That is called opportunity cost. If the money had the money been with him, he could have utilized. He has been deprived from utilizing the money. He would be on the belief that he will be compensated. You kept the money for 9 years, not only 9 years, 12 years. Then suddenly you say, oh, we have enjoyed your money, take your money, but don't claim any interest. Is it correct, Mr. Thakur? Not correct. Otherwise, I'll forget. Okay, let them file affidavit, but your money should be no.
Income may be cancelled, my lord. Income may be cancelled.
Let them file. Yeah. Third, the case, H. Sharma. For the petitioner, H. Sharma. Additional senior government for the one, D. Bhushan and pending for the 20. Any finance? Mr. H. Monica and pending and pending competent in Mr. Bhushan, sending out the GC, has submitted that instructions received. Okay, necessary instruct to file affidavit in opposition. I think here both accountant general and finance they require to file affidavit.
Yes, sir.
Because to protect the money of the
They have to.
both. If accountant general is not giving interest, somebody has to give it. Then it is finance. If they can sack the responsibility, then responsibility will fall upon you because it is your decision who has taken to shift the thing from accountant general to you. Am I clear? And the same will be filed within few weeks' time. He has just sought for few weeks' time to file such affidavit. In view of the nature of issue involved, comma, the counter affidavit on behalf of the respondent number 4 and the respondent number 5 should also be filed within a period of full stop. The affidavit of the respondent number 3, 4 and 5 to traverse the issue to traverse an issue, traverse the issue. If GPF account is to be closed,
As per this instance.
no, that notification is finance and accountant general. That's all. And High Court is filing. High Court is filing already. They'll be filing. Others are what? We have nothing to do with because no, Mr. Boisho is filing. If there is no submission from your side, so I have said that they should also file their if also traverse an issue. In the letter dated 16/3/11/2023 of the Office of the Principal Accountant General ANE Assam, annexed as Annex 8 to the writ petition, it is mentioned that the GPF account allotted by the Accountant General Assam and contributions made thereof will be refunded with interest up to the month of 31/12/2011 and no claim of interest on GPF accumulated money beyond 31/12/2011 is admissible to the subscribers. Full stop. The question therefore arises is that who will pay the interest on GPF accumulated money beyond 31/12/2011 to the subscriber. Please the case after 2 weeks. It should pay for interim leave is open for complaint.
Interim may be completed.
Open for complaint. Oh, your another letter, introduction. This is finance. Okay. A copy, it will give you. Copy of the letter bearing number so and so, dated so and so, of the Government of Assam Finance within bracket Budget Department, comma, placed by Mr. Mojumdar and Standing Council A&E, Article is kept with the record by marking it as X. Give it to him.
My lord, registry may direct to my name.
Okay. The office to reflect the name of Mr. G. Boycho and Standing Council. The respondent right,
Obliged.
comma as requested by. Yes, Ms. Bormont,
My lord, the instruction have been received, my lord. That's why I have to
received.
receive.
Hand it over. Trace map is received.
Sorry.
Trace map.
Press map is not received. Then taken that they are not position holder, my lord.
Huh?
They are not position holder, and
I think only prayer is please provide me the trace.
press map, my lord. They have it.
So what is the big issue there? Main prayer is that trace map of government land measuring 4.5 acres.
Yes.
Covered by DAG number 196 at village Swain, Moja Swain. What is the big issue then? Secretive document.
No, no. I have just yesterday I have received that.
Is there anything?
So they have mentioned the direction from Revenue Department. The following criteria required for press map are followed. The plot should be of a patta land. Applicant should be a pattada. These are legally that anyone having interest over the land can apply for issuance of press map. The patta should be a account holder from the pattada. The applicant must furnish complete details, patta, DAG number. So it seems that above the applicant did not submit the application as per above criteria. So these are the
Land
criteria.
is not a patta land. I'm on government land.
So they are saying that this is the
It
criteria.
my-
If you don't have any interest over a particular plot of land,
More than 20 years, mill.
you are an unauthorized document.
No, mill.
Or what?
No, mill. That certificate is also issued in this
Huh?
department. Connected to mill.
What certificate?
Circle officer issued a certificate. Showing my
On
position.
Harmon course 76. Senior citizen. Pakka house, 40 years.
Connected to mill. Circle officer.
Possession of government land. 40 years. Circle officer
Connected to
certificate. Circle officer certificate. Then page 18. District Commissioner says that apply before the circle office.
accordingly I applied.
Huh?
Accordingly,
He applied. District Commissioner directed him. Apply before the circle office. He applied before the circle office. Now circle officer is saying what?
Same scan as
Huh?
he is also we have also received the instruction letter in the same line.
So, Madam Roy, there is a office memorandum guideline, standard procedure for providing service of issuance of trace map from circle office. One needs to be a patadar or his or her legal heir to obtain trace map. Admittedly, you are an occupant of an government land. So you are not entitled for a test. That is a policy of the government.
File affidavit.
Huh?
File affidavit.
No, what is the office memorandum? Policy of the government. What more is required? Admittedly, you have been saying that you are in occupation of government. You are not in patata. For what purpose you need that?
Because government has stopped taking revenue from me. Suddenly stop.
Bedokoli Jorimana.
That has already been discontinued.
That has process has been discontinued. You prefer for settlement application for allotment settlement, that is a different thing, but otherwise, as per the policy of the government, gave payment, that is, patata is only allowed to have it. Hard MS as Roy Granite House for the petitioner. And otherwise, I thought of giving, since he is a senior citizen, but at the same time, he is unauthorized, in fact, encroacher and revenue here, Mohanton, and standing up.
No eviction notice. Not an encroacher. I'm paying. Circle officer has issued. I'm in possession.
What is certified? Please tell me. What does it certify? That you are in possession of government plot of.
No notice was given me.
Show me permission to enter into government land. Show me permission.
I will apply.
Anything who enters into government land without permission from the deputy commissioner is deemed. We are not observing that. And M. Bormot and junior government. The case of the petition is that he is in occupation of a government plot of land measuring 4.5 acres and covered by tag number 196, situated at village Lukura, Onia, Papua Revenue Circle, Moja, Rohmoria, District, Dibrugarh, sub-district. By constructing a pakka house thereon, for the last 40 years. Where is your revenue received?
Revenue is annexure 1, phase 11.
It is a case of the petitioner. The petitioner is paying. He had been paying revenue for the subject in respect of the subject since long. The circle officer, Sabah Revenue Circle, by issuing a certificate on 21/3/2020 to 2002, had also acknowledged the fact that an area measuring 4 bigha, covered by 193. was in possession of the petition for about 20 years. It is in the above backdrop, the petition had prepared an application before the respondent authority for a trace map of the subject lot. So, when, despite making applications before the respondent authority, the trace map was not provided to him, the petitioner's approach explored by the instant taking direction to the responding authorities to provide a trace map in respect of the subject lot. Para. MS Bormon, learned junior government advocate. Representing the respondent number 2, 3, and 4 has placed a set of instructions provided by the Office of the Deputy District Commissioner Dibrugarh by communication bearing number so and so dated 29/3/2000. So, para. As per the and the same includes an office memorandum bearing number so and so dated 18/1/2020 on the subject, quote unquote, general guidelines regarding the standard procedure to be followed for providing service for issuance of trace map from circle. So, as per the said eligibility criteria, as per the eligibility criteria prescribed the state office memorandum, it is only a patadar or his stroke, her legal heir or attorney holder, or there is another one, madam. Anyone having interest to provide it, or anyone having interest over the land can apply for issuance of a test.
The thing is, my lord, that where settlement operation is going,
Huh?
interest in relation to the settlement operation.
Which one you were?
Service can be obtained with the service of the service officer where settlement operation is going. Second line of
Second line of?
the notification.
Madam, he's a senior citizen, 76 years old. Please provide him.
I have no objection to that. I am just notifying that clause.
Though the state office memorandum has mentioned that an application, the service of providing test map is a service under the Assam Right to Public Services Act, 2012. Do not like it. Though the petitioner is not a patadar in respect of the subject lot, it transfers from the certificate issued by the circle officer Sabwa Revenue Circle, white number so and so dated 21/3/2002 page 13 of the report. It is noticed that the petitioner falls in the category of person having an interest over the subject plot. So, considering the fact that an application has already been submitted by the petitioner before the Circle Officer Sabua Review Cycle on 26/12/2023, and the fact that the petition is a senior citizen, aged about 76 years, this court seems it fit and proper that the respondent authority, more particularly the respondent of a court, shall issue a test map in respect of the subject within a period of 30 days from date of submission of a certified copy of this order. It is accordingly ordered with the above direct observation and direct with the observation made direct the restriction stands.
Okay.
The set of instructions placed by MS. You require it?
No,
Be careful.
maybe kept.
Pardon. Yes, anything? There is no representation on behalf of the petitioner today on call. Mr. P.J. Tulkar. Oh, okay. Very important. That's fine. One, 2, and 4. Say that instructions are available in view of non-representation on behalf of the petitioner of and instructions are available. Up to my pleasure, Lordship. Lordship, in this case, my Lord, petitioner applied for victim compensation, page 38, by this order, my Lord, on 14th October 2022. Page 38, relevant portion, my Lord, page 40, an amount of rupees 5 lakhs has been allowed as for final compensation for the rehabilitation. That since 2022, till date, my Lord, the amount has not been released. Yes.
Appearing for fund number 3, the Assam State Legal Service Authority, I filed my affidavit. Can you take up page 48, running page 48? This is the instruction we have received for DLSA Golpara. An amount of 2 crores 94 lakh 40,000 is still pending.
Government is not providing the fund.
Lordship, in fact, to that extent, I have also placed on record the next page, Lordship. Fine. There is a PIL which has been taken up by the Honorable Division Bench of this Honorable Court.
Okay.
And this is in the context of non-payment of funds to the State Legal Service Authority. And that is being taken up in a very rigorous manner by the Honorable Chief Justice. It is listed on 20th May for further instruction of the government as to why funds are not being released to the state. His name, as per the instructions received from Golpara, his name is at serial number 12 of the list of 11 of the year of 2022. Now, the moment funds are released here, we will naturally.
Yes, anything? Then you follow this after proceeding after matter.
Can we adjourn it for a few weeks and then perhaps
Heard Mr. M. Kandakar, learned transport of petition. MS M. Bormal, learned junior government progression for the number 1, 2, and 4, and MS R. Statutory and Planning Council. ASLSA for the response number 3. Full stop. 1 and 3. 2 is final.
3 and 1 and 4.
Sir, H. Borua, learned council, representing Mr. P. Gokul, Planning Council, Finance Department. The subject matter of the litigation is not non-disbursement of the amount of victim compensation amount of rupees 5 lakh. Pursuant to the order dated final order dated 14/10/2022 passed by the District Legal Service Authority, Kolkata. MS Chaudhary, Learned Planning Council, ASLSA, has submitted that subject matter of this submitted that
It was a pure
the
possibility
fund
of fund.
required for disbursement of victim compensation amounts under the Assam Victim Compensation Scheme, has not been provided by the state. Requisite for disbursement. It is submitted by Mr. Chaudhary that the matter of not providing fund under the Assam Victim Compensation Scheme 2012 is subject matter of a PIL, PIL 7 2020. A copy of the order dated 5/4/2020 passed in PIL number 7 2020 has been annexed to the affidavit in opposition of the point number 3. Having regard to the observation made in the order dated 5/4/2024, later case will be listed after 2 weeks to enable the learned counsel for the respondent to place further instructions in a matter. May I please date, my lord? If that is there, they will act accordingly. My lord. My lord. Tendency, my lord.
So that's already there. That
Always-
observation is already there.
Required.
Funds will come
Ah.
immediately.
I'm
Literally.
LSA is not at fault. Fund is the problem.
If it's a matter related to GST,
So extension
we
notification
have
matters. to
challenged the notification issued by the central government where time for filing reason has been extended.
Force majeure.
Lordship.
If although affidavit could not be filed by the either state or the central government, but what if the law point is involved? What if they can take up the matter? Because 17 matters will be listed before your purely on the question of law, whether the notification is sustainable. Section 168A, the GST.
No, where is the notification?
Page 41.
Page?
Page 41.
40?
41.
Not 41. Perhaps 44.
Oh, maybe.
in this
44,
repetition,
44 Lordship.
and 45.
Lordship.
Whether the issue is pending before Supreme Court.
Lordship, one issue is pending before Supreme Court
one?
because in these read petitions, Lordship, in my humble submission, number one is to be decided whether the extension notification are valid under the law. Another issues will be that most of the demands are under section 16.4 of CGST Act, Lordship. Section 16.4 Supreme Court matter is pending, Lordship. And
Or
the
is 16.4?
16.4, Lordship,
Extension of not filed.
says if the returns are filed beyond a prescribed time limit, the input tax credit will be lost. So that is under challenge at Supreme Court, Lordship.
One repeat, 4 read petition is pending before December 16.
16.4.
16.4. Section 16 subclause 4.
If I may please read, Lordship.
16.4. Let me arrive at 16.4. Yes.
A registered person shall not be entitled to take input tax credit in respect of any invoice, debit note, for supply of goods, service, or both, the due date, furnishing the return under section 39 for the month of September following the end of the financial year, to which the invoice or debit note pertains to furnishing relevant annual return, whichever is. The virus of this section was challenged before different high courts. 5 high courts as upheld the
Upheld the wire. Those are not ultra wire. But from the Patna High Court, the case went up to the Supreme Court, Lordship, and it is pending. Notice has been issued on the interim stage also.
3rd of January, Lordship, LP was notice was issued, but stay was not.
The matter is supposed to come up in July, Lord.
Here, Lordship, in this read petition, section 16 was
So
Not telling.
not checked.
16.4 has not been challenged, Lordship, but there will be two aspects to it. Number one, the wires will be decided by the Supreme Court. Number two, this language which has been employed, Lordship, a registered person shall not be entitled to take input tax credit. Now, what is that meaning of the word take which has been employed, Lordship? Our proposition is as soon as we
No,
take it.
whether this 16.4 in any manner challenged in this thing.
No, but it has to be read into, Lordship.
No, get into is one thing. Whether it is directly challenged,
It has not been challenged, Lordship, but it has to be
if it
interpreted.
is challenged, then it will be within the province of the division.
Yes.
It has
Right.
not been challenged.
So if that is not challenged, then why should we go enter into that?
Interpretation of the word take, Lordship. How to take input tax credit? Whether it is by taking it in the books of accounts or whether it is by taking it by filing of returns.
Yes, simply that the extension notification has been checked.
Holding the notification number so and so, ultra vires the provisions of whether this
168A.
kind of challenge is to be before division bench or single bench.
What if actually what happened? This question was raised by me. So Lordship had decided since this is main act has not been challenged.
Section has not been challenged. Notification has been challenged. So Lordship was of the view that it has to remain here.
Lordship has passed many orders in different days.
Lordship had given 2 dates to give any notification. But in the absence of such notification, Lordship was of the view that it should
And
continue.
our High Court rule says that if the section has been challenged, or rule that the rule is challenged, then it will for that. But regarding
But here notification has been challenged.
subordinate legislation, Lordship, nothing has been said in our rules.
Not there.
Lordship consider this aspect of it.
But on what grounds? Just
The notification, Lordship. Lordship will go through
this is
section
under what 168.
168A, Lordship.
Power of government to extend time limit in specific special circumstances.
168A, Lordship.
Now, what is the recommendation?
Yes, sir. That,
Part of the record.
no, Lord.
No, it is not yet a part of the
And
record.
it should be part of the record, Lord.
It is placed, but on last revision, I
Because,
submitted,
because it appears
That
so
will
far
be-
as it is with a non-obstante clause.
Yes.
And since 168 is not changed.
Lord.
It is the nature of the notification which is challenged.
The notification itself because of absence of special circumstances as mentioned in the section, Lord.
Now there could be two questions. It is in March 2023. I think it is your submission, if I remember correctly. Pandemic was not there.
Lordship.
That is what you. That is main plank of your. That will be, I think, main plank of your argument.
Lord.
One of the.
Lord.
Subsection 2 says, otherwise, subsection 1, it says extend the time limit.
Lordship.
So extension, my privacy view, subject to correction, should be within the period, permissible period. But subsection 2 clarifies that it can be with retrospective effect.
Lord.
Now that, I think subsection 1 and subsection 2 perhaps may not be, because these are not challenged.
Lordship, not challenged.
Now question is explanation perhaps.
yes. Their ground is
Only explanations.
Lordship.
Now here also, otherwise affecting the implementation of any of the provisions of this act. I think this is the core issue.
Lord. Lord.
If I
Lordship.
then there are two things on a privacy glance that regions are not reflected.
yes, they say the reason is not sufficient.
Regions are not reflected. Where is the reflection?
Notification.
In a notification.
Page 44.
Exercise of power conferred under section 168A, the Central Goods and Services Tax Act, 2017. Right with section 20 of Integrated Goods Service Tax, section 20 of Indian Territory Goods and Service Tax, and partial modification of the notification of the Government of India, Ministry of Finance, Environment and Law, publishing Budget of India, Acknowledgement, the government on the combination of council
Right.
hereby extend the time limit specified under subsection 10 of section 73.
You have followed the provisions of subsection 1 and subsection 2 literally. Now to test legality and validity,
The discussion,
otherwise
recommendation of the
otherwise affecting the implementation. Now, there has to be, on a privacy thing, regions are to be, should be there. Or otherwise, regions should be there in the contemporaneous records.
Yes.
And for that purpose, Mr. Kyle has to assist the court. What are those regions which guided
one of the repetition.
the authority to issue this notification?
Yes, yes. And that was disclosed before your lordship in one of the repetition. The minutes of the 49th GST Council. It was considered and passed order that we will consider at the time of
But here also,
Yes, Lordship. We'll
you have to
place-
bring it on
It had to
record.
be on record, Lordship.
We'll file a common affidavit.
You can file a common affidavit. That will,
And Lordship, this point was already decided with the Supreme Court in case of Naresh Kumar Agarwal. So matter relating to Chartered Accountant Council, where how, in which manner, if a challenge is made to subordinate to the how which point has to be considered and
Very good.
place this judgment before your law.
Okay.
Please also control.
forgot. I have forgotten.
I'll place Lord.
It's a legit-
So that they can also respond. If place this GST Council recommendation, what are the factors they have considered for extending the period to exercise the power to enable the central government to exercise the power under 160. So it started from the GST Council.
Yes.
So they recommended.
Yes.
And government acted on it. So region should be reflected somewhere.
I'll place a common affidavit.
How they have applied their minds. I think that will be, if it is not pending or no stay is granted.
There has been
No. By the Supreme Court.
no. Even that point is different, and here the point is different.
Here is basically this point.
This is extension, special circumstances. And
This
Supreme
one-
Court is 16-4.
It will be restricted to only explanation.
Lordship.
Yes.
Lord.
Lordship, 17 matters has been listed today before a Lordship. Item number 25, 26, 27, 28.
Interim orders are of what nature?
Lordship,
Order shall not
Till
be
further
enforced.
order.
if Lordship, if the final order is passed, they should not be implemented. If notice is only notice has been challenged, then the payment directed not to proceed with the
A recovery of the amount assessed. There is interim order, as final order has already passed, taking note of the so and so similar various inclined provided till further order.
Yes. In where the
So we do not have to reflect this again,
not
that interim order is to be continued.
but Lordship, one
It is already there.
in those cases where only notice has been issued, that has been challenged, where Lordship has passed, please to pass order, directing the authority not to proceed with the matter till next day. Here,
Lordship, my learned friend needs to submit that first when the bunch of cases came before this court had ordered that in cases where only notices has been issued, final order may not be passed. Such was the interim direction of this court. Subsequently, the interim order was revised by this court, Lordship, and the nature of orders came to be that the recovery shall not be enforced in cases where order has been passed. And in cases where order has not been passed, the order may be passed, but the recovery shall not be enforced. So maybe he.
So whether that observation is with the rider that till further orders of this court.
Lordship.
If till further orders of this court, then we need not have to repeat again that interim order will continue till the next date of listing.
Lordship.
If that is in agreement, then we
Yes,
will not observe about the interim. protection.
in those cases where final order has been passed, there is no need to pass any further order because order is already there. But there only in notice.
We'll go one by one and better these are of council part of petition. Central government, anybody? No. Unless I love B. Choduri. Oh, it's K. Pukon. Central Government Council for one first prayer. B. Choduri. You are B or B? B. B for Bombay. B. 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 Choduri. Standing up. Assam. Number kita update. Okay, Mr. Kyle, when Mr. Kyle
In some
City
cases,
Council
in some cases, it is to
both.
yes, both. But ultimately, also we have to defend because the notice was issued by the central.
Whether they are required to be filed.
It is few of the.
There are both type of cases, Lordship. One set of cases proceedings by CGST, another set of cases proceedings by SGST. The state.
If the extension goes, the notification,
Everything goes.
extension notification goes,
Everything goes.
consequential order will follow.
Lordship.
Consequential, there will be consequential action.
Lordship.
Is it not?
Lordship.
Basically, it is a notification.
Yes.
Notification issued by CGST authority, not issued by state authorities who are now telling that we have adopted it without issuing it.
So it's a composite tax system. Central government has to issue notice or they are adopted.
Okay. Who will file the affidavit? You.
Will both.
Both. Okay. Both. Mr. Shurfil and Sadiq. Mr. Kyle and Sadiq. Yes. I've got for how much time? 4. 2 weeks.
Because we have prepared affidavit that is sent to our legal department.
Uh, to time to file counter affidavit. Their respective counter. The price allowed is like 35 or 3rd of June.
No.
3/6.
No.
No, by here instruction but chemical from interim order file on Monday. This is 25. What kind of interim order? Let me check. Still further order. Same. The hearing of the however till further order. Same. Any final order
Can
cannot
remain.
be enforced.
Same can remain.
Same then.
Lordship.
Nothing to be interim order click. Number file over खाली. It should be kept one until number after. Till further orders. Okay. Item number 28.
28 probably same.
Up to 28 same. Nothing to be observed as regards interim. Panira. Till further order. Okay. Any other cases?
Lordship, I will have 4 more cases, 39 to 42.
Now 39 to 42 sound. Question will be otherwise affecting the implementation of any of the provisions of this
Lordship.
act. Only that is
Lordship.
no war, no flood, no drought, no fire, no cyclone, no earthquake. Epidemic, maybe
Yes. That was the reason. That was the
only epidemic or
How far it affected Lordship?
otherwise affecting them. And that is the issue. Further orders same number লিখি রিপিট করে দিব ডেট একে দিব further order. Forty-one. Same. Up to 41 or
Up to 42, Lord.
42?
Lordship, my friend will have similar. 31,
Your number
31,
31, one by one. Thirty-one to do. Issue is same.
Issue is same.
issue is same. In this case, the final order.
And the interim order is until further order.
Oh, further order. RS Mishra. Petitioner. 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 ये पुकान लिखो सीजीसी ठीक है नंबर पर आपके चौधरी के पास से 40 31
Then 32.
32.
This is also same, my lord, until further order.
Final order has been passed.
Till further order.
Yes. 33. Same.
Further order.
Yes, ma'am.
30.
Then 36.
30.
Item number
We are almost end of the match.
33. Office has been checked.
30?
33. Office has been checked.
Till further order.
Yes,
No,
ma'am.
if the department is, if they have to pass final order within a specified, the order is not passed, then
33.
revise the order, directing that government not to proceed with the past final order, but it won't be raised. It will be not be raised.
No, what?
Local notice was
No, what promoter you can keep a Sara for 20. After hearing the learned counsel for the parties, comma, and as agreed to by the learned counsel for and as agreed to command the interim order stands modified to the extent that the responding authorities may proceed to pass the final order, but if by the final order, comma, any recovery is contemplated, comma, such recovery assessed against the petition shall not be enforced until further. This is order in
30,
item number
33. Then my lord, 36.
36.
here also notice was
Local notice.
Okay, same.
Same.
Modified.
modified.
No recovery until further orders.
Then 37, my lord. Here, my lord, order is
Here order has been
order is passed.
Order passed.
Yes, my lord.
Nothing is required to be observed.
lots.
Then 38.
38.
38. Here also so-called notice.
So-called
So-called.
needs to be modified. No recovery until further order. Modified. Over
Only 2
My
minutes
lord,
left.
43, my lord.
43 and 44.
43. Modified.
Modified.
Then my lord, 44.
44 also modified.
Modified until further orders.
Okay.
Shall not be enforced. Amount, huh?
Okay.
Lordship, in this matter, we received instruction, Your Lordship, that you file an affidavit, Your Lordship. I have also received my affidavit. I have.
A fixed date maybe lordship may kindly be placed because there is
Two weeks,
noise.
then we shall go with 2 weeks, Your
But
Lordship.
after 2 weeks, a fixed date lordship.
2 weeks. 2 weeks. They heard Mr. A. Kolita, Land Council for the petitioner, Mr. R. R. Gogoi, Land Standing Council, Environment Forest Department for response number 1 to 5. Who is revenue?
Lordship,
A border side. Land Standing Council Revenue Department for response number 6 and 7. Mr. J. Handy.
or 8 and 9.
Leonard Junior from Assam for response number 8 and 9. And Mr. S. S. Rod, Council for response number 10. So 2 weeks. Mr. Bhattacharya is required? No. Will support Henry. Mr. Gogoi, Standing Council, Environment Forest. And J. Mr. Henry. And Mr. Rod. Land Council for the have all paid for and are granted 2 weeks time.
2 weeks lordship. 2 weeks is like
2 weeks
your,
time.
I mean, your outlet is only getting stalled.
Or to file their respective counter affidavits. Please the case.
5, 6, 5th June.
June.
Obliged, Lord.
My lord, in this matter, my lord, the opposite party was supposed to file affidavit. my
Not
lord.
there in a revenue record for which petition has been
Lordship, I
filed.
need some time.
Okay, Mr.
T Nath, my lord.
B. Nath.
T Nath, my lord.
B. Nath. Petition. Petition. Able to say JNT. JNT. Report. B.
Lordship,
3 weeks
Lordship, let it come after my lord accounting.
after elect result. 4 weeks time.
Like,
Listen. To file counter. To obtain necessary instruction to file counter. Listen.
May I please, Lordship? In this case, Lordship, they are supposed to obtain instruction. But we have a
The CPI to consider the father of the petitioner is the owner of the plot of land in the area of land is 7 because was made leading chapter with the petitioner in a minute path. Yes,
We already been communicated, Lordship, some time may be granted.
okay then.
small issue only direction.
Everybody is busy in election. Everybody is busy in election. M. Khan. Petitioner. Able to say the revenue 1 and 6. 1 and
Lordship, I am
Six.
for 3, 5 and 6.
3, 5 and SR Rava. Standing count. It is for number 4. 4 and
4, 5 and
overlapping. Now,
no, my
ah,
4, 5.
4, 5, 6. And 6, 6.
I'm for 3, Lord.
Then Rava and handicap. Or who is okay? Ceiling top. Who is the
decision making authority during surplus time.
Now it is before the government lordship.
Lordship, my learned friend.
Huh? You have to get it. He says, we are in 2024. He says that in 1976, so that time BTC was not there. So he is a deputy commissioner and
My lord, that my learned friend can.
you both take instruction.
We are both, sir.
Mr. Hendrik, Mr. Bhattacharya, and Medical Revenue. And Mr. Hendrik, and shall obtain instruction as regards right shall file counter bid. So what they have thought, you can to obtain and file counter bid. So after our out, it's okay. Get the instruction. Long pending. Records are there or not, I don't know.
May your lordship, my senior is different.
Your senior, who is your senior?
Tikeda.
Applicant is also not there. Learned counsel for the applicant is found. Applicant is on call. Mr. Oh, you're there.
I am for the applicant.
Okay. Your senior Pikeda.
Yes.
He's absent.
No. May I take that?
Okay.
Okay, yeah. Already service is complete.
Let him come. There is no representation on behalf of the party. Yeah. Fine. Yes.
As per order dated, my lord, 3/4/2024, passed by this honorable court.
From the
Paragraph 5, my lord, 4 and 5.
Planning Council, Revenue Department.
Yes.
Or Deputy Commissioner, Kamrup Metro. Were asked, who is the additional deputy?
Correct.
Yes, indeed.
Well, they have filed an affidavit, my lord. Your lordship kindly see their affidavit filed. Second,
Sir, I don't know, after deliberation, this order was passed on 3/4/2024.
my lord.
I think you were part of that deliberation. Court is inclined to direct the district commissioner to inform the court through their learned standing counsel for the revenue department the name of the concerned officer who was holding the post of additional deputy commissioner in charge of land record branch.
Correct.
Right? And this court has already observed that deputy commissioner and so was not directed. So we are not issuing notice.
No, my lord. My lord,
It is only the additional deputy commissioner.
yes. Respondent number 3, only my lord.
Now,
And my lord, the deputy commissioner accordingly, this honorable court has directed a standing counsel
That is, why you are repeating what I have already submitted?
Correct. Yes.
Or have already asked. Why you are repeating? After some time.
All right.
Let him take instruction. Who is the person who was directed?
I received one
No, why it is come for order?
affidavit, Lord Sabha, that would not prepare the affidavit, because the record is
Say. Why respondent number 7 is required to be served by registered post? I don't think.
7 is the executive engineer. Normally it was.
Mr. Gogoi can be called.
Yes, yes.
Yes, any.
I think
Mr.
there is-
Gogoi or Mr. Chaudhary, B. Chaudhary, standing counsel PWD. I think that will expedite.
Well,
But so far, Praveen Bora, respondent number 8.
I don't know. Somebody has, my learned friend is saying that somebody has filed a direct instruction before the court. I don't know that. I have not seen. My learned friend has checked the record. Some executive engineer has filed a direct, I think, instruction before the. I don't know, my lord. Your lordship will know. That is while my learned friend.
This is not the proper
This
procedure. at the
procedure
Tika
has
court.
to be through a council to be represented.
Okay, let him come. I think he should
even
represent.
I need some time because my lord that
And
original
this
record.
is not served on 8.
8 is the private party.
It has notice has only gone on 1/5.
No, that
We are on only 9.
actually he has to complete. But the issue here is the land acquisition matter, where the money, structural land compensation has to be paid to us. But what they have done is they admitted fact by the authority concerned, it was given to a different person. Name is same, father is different. He took away 50 lakhs, which belongs to us. And that is a admitted position I have annexed. The admitted position by the authority that mistakenly we have given to another person. Admitted. And there is an investigation which is going against that person. Police investigation going, and my money has been taken away because our name is same. Praveen Bora, here is a son of the.
So what is the solution then?
The solution, my lord.
Let them.
Yes, ultimately your
Firstly,
lordship.
they have to give the response.
No, 100%, my lord.
And if they had done some officials had done it, but at least there should be some indemnity bond, right? If that's available, then we'll decide about how to
Now
restitute
now the question,
your position.
That's my point. Not to raise. This is money which has been given.
Right.
Suppose the
How to
department.
recompense?
No. Suppose department has paid it. Let us say the department has paid it. Ultimately, department has to pay Mr. X, and it has been paid. Now, what is the solution of the court? In what manner it can be given back to me?
That is what I have
No,
indicated.
that's why I'm saying, my lord, if the department has something done wrong, so it's a department who has to pay me.
That is what I have
Your
indicated.
lordship has to only hear the other side. That's true.
That is what I have to. I have indicated tentatively that let them come with their proper stand. And generally, when an amount is released, there is an indemnity bond by that person.
Correct, right.
And the state has the right to recover. At the same time, how the petitioner is to be compensated.
Right.
So
Let
that stand has to
them go.
come.
Yes, of course.
And you have to show that, yes, they have done wrong.
Because it is, I will show it. We admitted by the department itself. Admitted. That's the whole problem. Admitted by all the concerned. All the concerned admit.
Let them come.
Yes.
But if that person I have received that original record is not available before the deputy commissioner. It was sent to that additional district judge. That's why we could not prepare the
Okay, take your own steps. That is between persons interested inter se. Here it is not persons, but claimants. There are many claimants in respect of a particular amount of compensation awarded under 3G1. Right? That is regarding apportionment. Please see apportionment. Here is an act of fraud.
Yes.
But the petitioner is alleging an act of fraud. And this fraud is being attributed not only to the respondent number 8, to the officials of the department also.
Right.
Okay, Hart, Mr. Where is Mr. Gogoi? B. Chaudhary? Okay, let him come. I'll explain. Hart, Mr. D. Das Nair, Senior Counsel, assisted by Mr. K. Mohammed, Learned Counsel for the petitioner. CGC. Earlier, DJ Das appeared. National Highway? Nobody is there. Okay. Mr. J. MSPR Mohanto, Learned Standing Counsel for Revenue and Disaster Management Department for Respondent number 4. Mr. J. Hendrick, Learned Senior Government for Respondent number 5. 5 and 6. 5 and 6. And Mr. Soin, Learned Standing Counsel. PW. Mr. Seaboard, Standing Counsel, NHA, for respondent number 2 and 3. Motorcycle, Revenue, 4. The respondent number 7 is an authority of the Public Works Department, Assam. By the previous order, the petition was directed for service of notice under respondent number 7 by registered court as well as by usual process. So such steps were taken by the petitioner. However, as there is a set of standing now for the Public Works Department, Learned Counsel for the petition, Mr. Mohammed, Learned Counsel for the petition, shall serve a copy of the writ petition along with annexure to Mr. So-and-so, Learned Standing Counsel, Public Works Department, by tomorrow, Monday, within 2 working days from today. Mr. So-and-so, Learned Standing Counsel, has appeared and accepted notice of the after process. As such, respondent number, service of notice upon respondent number 7 is deemed to be complete. Full stop. In view of the office note dated 1/5/2024, await for a report as regards service of notice upon the respondent number 8. So, it is noticed that the communication is made to the Assistant Registrar, Guwahati High Court, from the end of the respondent number 7, forwarding Ferrer's comment to as such practice is not accepted, comma, the land standing on PWD shall file the counter affidavit on behalf of the respondent after obtaining instructions from the respondent. We are not taking note of this. This is not accepted.
It's okay, fine.
Quote, Mr. and Mr. Borua, you want to file anything? Yes, your money. Mr. Borua, Standing Council, NHAI, and Mr. Hendik, Junior Government have paid for. How much? 4 weeks to file their respective counter. Please check it. Okay, NHAI. NHAI.
One matter, sorry, your lordship, I think. One matter, item 51, I think.
Yes.
Today- Yes, we have filed an affidavit today. Reply. We have filed against Mohanto's reply. Objection. Objection.
Vacation.
Okay.
Can it be on Tuesday, my lord? Because we have some.
Okay, Tuesday.
It is in the state vacation column.
Tuesday we have listed. We'll take up.
I have, if your lordship will kindly accommodate, one matter was fixed.
I'm.
That APS is so
My-
excellent.
we are both-
You just see.
Because in that we are also both.
Okay,
My
Mr.
lord,
Pidas, Learned
So
Council,
important.
Senior Council Court of Petitioner, and Mr. TJ Mohantal, Learned Senior Council, for the respondent.
Applicant.
Have got listing of the case on Tuesday. Tuesday?
Yes, my lord. Along with the, they have filed my.
Good stuff. It is stated that objection,
We have filed objection.
an objection to the interlocutory application has been filed on behalf of the OP, opposite party, the state petitioner, in I Civil 1126/2024 today. Good stuff. Release the case on Tuesday. Take to review with a said objection. আজি কোনটো fix? কোনটো? Okay. With the said objection stated to have been filed by opposite party. The interim order passed.
May with regard to item number 47, your lordship, is a review petition. We are meant to place judgments before your lordship today. If lordship is sitting at two lordship, may play the matter may count.
We found both parties were absent.
Lordship, due to some mistake on our part, lordship, mistake, lordship take judgment, lordship will take, can take up the matter at 2, your lordship. We'll be placing a judgment.
Yes. Okay.
Lordship will take him at 2, your lordship.
Serially.
Lord.
It's for what?
For continuation of delay of 52 days. Lord. the IA 2389 of 2009.
What are the grounds?
Lordship, the grounds are there that Lordship, after Lordship passed the order on 19 to 2000, Lordship, what happened? We filed a MSc appeal, and in that there was a delay condonation petition. That delay condonation was dismissed by Lordship, and thereafter Lordship, that order was passed on 19 to 19. And thereafter, what the insurance company did is, as a last year, they tried to find the insurer of the vehicle number WP25 that I have mentioned in para 5. And then they found that it was from West Bengal. And then at para 6, Lordship, I mentioned that the divisional office of the applicant was situated at Barasat, West Bengal, was to gather the information from the RTO there. Lordship, para 7, the investigator could gather the information on 9/4/19, and by his letter dated 10/4/19, he provided the information to the divisional manager, Barasat Divisional Office of the
Those
applicant.
are with regard to MSc appeal.
Yes,
No, no, no. This is after passing of the of Lordship's order, this inquiry
No,
was done.
the application seeking condonation of delay was we were not into the merits of the appeal.
No. No.
Right?
No.
So after dismissal of the application for condonation of delay, you preferred a review petition.
Yes. Yes.
Right? And that review petition was with delay of 52.
Yes.
We are not into the merits of the appeal.
No, no, I'm not talking about the merit. Lordship, why the delay happened? Why the delay of 52? This is what is explained here, Lordship. Because they inquired, instead of going to the apex court, they inquired, and then when they found that the policy was with New India Assurance, then this review petition was filed before Lordship.
Yes, you are for whom?
I am for my lord, respondent 1, 2, and 3.
Appellant, claimants.
Claimant.
Yes, what do you say about?
Yes, my lord, this petition is not at all maintainable.
Why?
Because the earlier delay condonation petition, which was dismissed, my lord, it was regarding
Whether that can be subjected to review or not.
my lord, not. It is not. The review petition is not maintainable. That is why there is no prima facie case, and the delay can also be not.
No.
Delay cannot be, my lord, condoned.
That order of dismissal of the application for condonation of delay,
Yes, my lord.
whether that is an order which can be reviewed or not.
My lord, that cannot be reviewed. That
Why?
is one thing.
No, why legally not?
Yes.
Cannot be reviewed.
Because, my lord, that is an order which was passed regarding delay condonation petition. Not
Why it is not?
it is not
not
related to
reviewed?
any fact, my lord. It is not related to any fact, my lord.
Your submission on the basis of legal provision.
Yes, my lord. Legal provision is, my lord. Actually, today, my lord, I am not in a position to, my lord, hear the matter, my lord, argue the matter.
If the review petition is not maintainable, then automatically this application for condonation of delay will not be maintainable.
Yes, my lord.
But otherwise, if the review petition is maintainable, we can consider only this application today.
My lord, some other aspect also there.
On the review, we will decide on merit.
My lord, some other aspects are also there.
No, what other aspects? Please tell me that an application for review of the order is maintainable or not.
My lord, for that, my lord, I have to get it as CP job.
Okay, we'll decide about that maintainability of the review application. For the time being, we can condone the delay. It is hardly for 52 days.
Yes.
Any
Delay
application.
is also, my lord, not calculated properly. It is not 52 days.
You are, since
It is
2019, you are not filing any objection or filing objection. You have filed objection.
Not filing.
Then,
Not filing objection, my lord.
for 5 years, you are not filing any objection.
My lord, I am not filing any objection because My lord, I'm confident because this petition is not maintained. in court.
Confident will not do. Confidence has to be
Because my lord,
drawn from the legal
they
provision.
they are bringing a issue, my lord, which is not at all to be decided by the my lord even in appeal also, because they are saying that insurance company is different company. The trial was
Sir,
there, my lord.
No. Don't go into the merit
Yes.
of the appeal, which is not yet born because of the dismissal of the application for condonation of delay.
My
And
lord,
review
this,
is also not
this
numbered.
provision, my lord, section 114, my lord, this is review. Here, my lord, I'm reading this. Subject as aforesaid, any person considering himself aggrieved by a decree or order from which an appeal is allowed by this court, but from which no appeal has been preferred. By a decree or order from which an appeal is allowed by this court, but from which no appeal has been preferred, it is not applicable. The next is by a decree or order from which no appeal is allowed by this court. Here it is covered, but by the next, my lord, by a decision on a reference may apply for a review of judgment to the court which passed the decree or made the order, and the court may make such order thereon as it thinks fit. My contention is that, my lord, this order, though, my lord, no appeal is allowed here against that order, my lord. This order, my lord, review application, condonation of delay, my lord. Against that, my lord, no appeal is allowed. But here, my lord, the fact, there is no fact regarding error apparent on the face of the record, my lord. Because this petition, my lord, this petition, what she is filing, my lord.
That will be decided in a review
Yes,
petition.
yes, my lord, what she is filing, my lord, that is, my lord, not related to the fact which was explained before the honorable court in the earlier proceeding, my lord. That is my submission. She is explaining a delay, my lord, which is not related to that, my lord. Fact.
Heard MSRT one has to be so notices have been served. Notices are found to be served. Now, when the opposite party number in the substituted command, none of them is appeared. This is an application under 65 seeking condonation of delay in filing the accompanying decree, is yet to be numbered. This number is the accompanying review petition is referred against an order dated
92.
referred under 47. Seeking review of an order in passed in comma number 1645 passed then fit comma passed along the memorandum of fit referred under section 173 for the motor vehicle 90. In this application, comma, after passing of the order dated 19 to 2019, comma, a certified copy of the petition was applied, and the certified copy of the order was received on 11 2018. So thereafter come on legal opinion was sought for, and the legal opinion was received on 12/3/2000. After receipt of the legal opinion from information about the alleged meeting right was sought for as the alleged pending bill was registered in the state of Venkatapura. Such information could be obtained through an investigation report dated 22/04/2000. The investigation report was received by Guwahati Regional Office of Tax on 30/4/2000. It stated that the concerned report was provided to the Land Records Council. Thereafter, Kamaru took video time to prepare the accompanying a period of 2 days delay has occurred in preparing the class party. No, so the application is right as perfect as income on 14/5/2000 note to the statement I've gone to the statement on the region from that explain the regions for delay doing submission. For the date of 52 days from official offer in preparing the company for and send it to of now the connect education there is just accordingly.
Hello, please.
My lord, may I say one thing? They are taking the ground that insurance company is a different company. It is not their company. It is a New India Insurance
So
Company.
those are merit. Those are on merit.
My
We
lord,
are on only a period of delay.
my lord, if required,
Argue those points at
that
the time
company
of.
may be implicated, my lord, in this proceeding. My lord, let them confirm that whether they
No,
are.
there is no implement. We are only on the order
Yes.
whereby the application for continuation delay in preparing the connected appeal was called. That's all.
Actually, he is also in one paper. He cannot implead, but that is correct because if the other insurance company is the insurer of the vehicle,
That
then ultimately they will be.
let us
Yes,
see
yes,
your
yes,
review
let us-
petition.
Yes, I
We are not into the appeal.
correct.
Publish.
Wait, please, your lord. Wait, please, your lord. My lord, this petition was disposed of as the counsel representing the petitioner made a statement that he would like to withdraw the petition and would avail the remedy available to the petition. Now, my lord, after the order was delivered, the petitioner could notice that number one, an appeal in terms of clause 24.1 was filed by the petitioner. If your lordship would kindly come to page 89 of the review petition. Page 89.
Yes.
Dispute redressal system. If any dispute or difference of any kind whatsoever shall arise in connection with or arising out of this contract or execution of the work or maintenance of the work thereunder, whether before its commencement or during progress of the work or after termination, abandonment or breach of the contract, it shall in the first instance be referred for settlement of the competent authority within 45 days of arising of the dispute or difference described along with the powers in the contract data above the rank of engineer. The competent authority shall, within a period of 45 days, after being requested in writing by the contractor to do so, convey his decision to the contractor. Such decision in respect of every matter to refer shall be subject to review as hereinafter provided, be final and binding upon the contractor. So, my lord, invoking this clause, your lordship will kindly come to page 59. Now, this was the on 23/8/23. It was filed before the chief engineer is the competent authority as per the ITP. So this was the representation. Now there is a reference of 4-5 letters with reference to the notice dated 21st of August 23 regarding PMGSY project. I wish to inform you that after receiving the notice to proceed on 4/5/23, we began mobilization effort. However, monsoon onset and subsequent flooding have submerged the project area. Safety detects waiting for flood waters to recede before work begins. And the same was intimated to you via my letter under reference serial number 4 above. In response to executive engineer direction, via letter under reference at serial number 1, submitted a revised work program via my letter under reference at serial number 4. Despite knowing the site challenges, the executive engineer concerned deemed our submission unacceptable without explaining any reason. It is pertinent to mention herein that no field official advised me about how to execute the work in present ground condition of site. Regrettably, a termination notice was issued
without any prior discussion notice. Contract allows 12 months time for completion of the project, which will be due in May 2024, and I commit to honoring this timeline. Now, this was filed on August, and timeline was up to May 24 because 12 months was the time. Please understand the revised work program importance tailored for safety and success despite challenges. We are dedicated to project success, appreciating its impact on our state development. Your reconsideration of termination would greatly aid our effort. So, my lord, there is a provision of filing an appeal. Our method dispute redressal forum was created by the contract agreement itself, and we availed it. Thereafter, my lord, I approaching the question of going for alternative, not going to the alternative remedy does not happen. So this aspect of the matter was, my lord, perhaps, my lord, not brought to your lordship's time. My lord, this review is not account of any fault of the court. I am in a situation when I have already availed the alternative remedy. Where is the question of I again going? Alternative remedy does not necessarily mean a suit. Exactly in a similar circumstance, my lord, there is a judgment of our High Court, a division bench judge, where review was permitted. Now, what had happened, my lord? Government of Assam India Education Department, they appointed some additional teacher. Now, there was a cabinet decision for, regularization of their services. In connection with that policy, some disputes arose when, my lord, an appeal was filed by the state. When appeal was withdrawn, then this review was filed. Please come to page number internal 5, para 8. When the writ appeal number 360/2014 came up for consideration before this court on 4/4/16, a submission was made by the learned departmental counsel that in view of the office memorandum dated 3/3/16, appeal had become infructuous. Taking note of the aforesaid submission of the departmental counsel, the appeal was closed as infructuous by order dated 4/4/16. It is the order dated 4/4/16 in respect of which state is seeking a review. The case of the review petitioners as projected to the pleadings is that on 28/2/16, the cabinet took a decision to regularize the services of contractual teachers without insisting on TAT qualification, and therefore the office memorandum dated 3/3/16 was issued. Accordingly, a concession was made by the learned departmental counsel before this court, which led to the closure of the writ appeal, treating the same as infructuous. However, when the issue of implementation of OM dated 3/6/16 came up, the government found that the cabinet decision dated 28/2/16 as well as OM dated 3/3/16 were not in conformity with the provisions of the amended rules of 2003. Not only that, it was found that implementation of the OM would lead to violation of several orders of the Supreme Court of India as well of this court. Having realized the mistake on the part of the government in issuing the OM dated 3/3/16, state has approached this court by filing the review. Sri so-and-so learned additional Chair Advocate General Assam has disarmingly submitted that there is no error in the order of the court, but review is being sought on the ground that concession given by the departmental counsel was based on a mistake committed by the state in issuing the OM dated. Sri Saikia submits that regular appointment to the post of teachers in secondary school has to be in accordance with the provisions of the rule, as well as the law laid down by the Supreme Court itself. This was the contention. Please come to, my lord, paragraph 17 at page 8. A perusal of the order dated 4/4/16 leaves no manner of doubt that writ appeal was closed merely on a concession of the departmental counsel without there being any consideration of the matter on merit. As noted above, the stand of the state in the review petition is that on a revisit of the cabinet decision dated 28/2/16, as well as OM dated 12, it transpired that implementation of the same would amount to violation of the rules of 23 as well as several pronouncements of the Supreme Court. Therefore, core question that would arise for consideration in this review petition as to whether the aforesaid ground taken by the state would be a valid ground to review, recall the order date. This was the question which was formulated. There can be no quarrel with the proposition that principles embodied in Order 47 Rule 1 CPC would come into play while considering an application for review. Under the said provision, an application for review would lie not only upon discovery of a new and important piece of evidence, but also when there exists an error apparent on the face of the record, or if the same is necessitated on account of some mistake or for any other sufficient reason. Interpreting the word sufficient reason as in Order 47 Rule 1 CPC, the Honorable Supreme Court has held in the case of BCCI versus so-and-so that the said expression would be wide enough to include even a misconception of fact or a law by a court or even an advocate. This is the precise report. And my Lord will kindly come to 19 and 20. In case of Shivdev Singh, the Constitution bench of the Supreme Court had observed that power of review inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct grave and palpable errors committed by it, or there is nothing that precludes a High Court from exercising power of review in such matter. Likewise, in the case of State of Rajasthan, the Honorable Supreme Court, after discussing various judicial pronouncements on the power of review, had summed up by observing that when self-evident errors come to the notice of the court and are not rectified in the exercise of review jurisdiction or jurisdiction to recall, which is a facet of plenary jurisdiction under Article 226 of the Constitution, a grave miscarriage of justice occurred. In the present case, it is not the plea of the review petitioners that order dated 4/4/16 suffers from any error, but the stand is that concession which led to closure of the writ appeal was based on a mistaken understanding of fact and law, which having been detected subsequently, state is desirous of correcting the situation. It is in furtherance of such objective that a prayer has been made for recalling the order dated 4/4/16 and for hearing the writ appeal on merit. There is nothing on record to indicate that the stand of the state is factually correct. Then Lordships may kindly come to para 23. In the present case, state has come forward with review petition admitting its mistake in issuing OM dated so-and-so, which forms the very basis of the concession made by the departmental council, leading to the order dated so-and-so. As such, a rejection of review application would amount to permitting the judgment and order dated so-and-so to attain finality of any default, which in our opinion would lead to miscarriage. We are also conscious of the fact that writ appeal preferred by the present review petition, assailing order dated passed by the learned secretary, declining leave to withdraw OM dated so-and-so, is pending disposal before the court. Therefore, in our considered opinion, writ appeal preferred by the state also deserves to be heard and decided. So, my lord, the misconception on the part of an advocate is also a ground. We are not saying there's anything wrong on the part of this honorable court, as in this present case. Exactly, more or less identical situation this review was held. All that we want is, my lord, a hearing on merit. There are other judgments also, my lord. Basically, my lord, it's on the scope of review power.
Must have gone through the order at page 71. If your lordship once again goes to the judgment order, page 71 of the writ petition.
Page 71
of the writ petition.
Writ petition. 7 or review petition.
Oh, sorry, review petition. I'm sorry.
Yeah.
That third paragraph.
Mr. Day, learned counsel for the petitioner, has submitted that the petitioner will not be pressing this writ petition in order to avail appropriate remedy available to the petitioner under the law. It is a contractual matter, Lord. So the appropriate remedy will definitely be damages. Lord, may kindly see the next page, Lord.
Next page.
7. It's a notice, Lord, on behalf of the petitioner. Lord, may kindly see the date on the next page, Lord, 23/9/2023. Order was on 29/2023. This notice was issued on 23/9/2023 by the petitioner through his advocate. Lord, may see the prayer there. The page 85. Page 85. What he is claiming, Lordship, as alternative, Lordship. Damages on account of loss of finance. Damages on account of loss of reputation. Damages of mental agony, torture, and physical harassment. Damages because of what, Lordship? At page 84. First
Yes.
line. The termination has caused immeasurable mental, physical, as well as financial losses and agonies to my client and lowered down the reputations of my client, track record in the society, as well as business among acquaintances and general public, and my client has to face social finance ostracism because of wrongful acts of yours. The response. So a prayer was made that the petitioner wants to avail the appropriate remedy, Lordship. And subsequently, this notice was issued. Lordship, may see paragraph 20 of that notice, Lord, page 85. Now, please take notice that you either allot the work to my client or pay damages. Failing which, my client will be constrained to have recourse to appropriate legal remedies against you. So a prayer was made that he wants to avail the appropriate remedy, and that was initiated. Now, Lordship, if this prayer, Lordship, if the earlier counsel who made a prayer before this honorable court, that the petitioner will not be pressing this petition in order to avail appropriate remedy available to the petitioner under the law. What is the mistake he committed? Where is the the misconception of fact? Any statement to be regarding this present petition, Lord? That no such instruction was issued to the council appearing at that point of time. That he misunderstood the law. That he has some misconception about the fact.
Right.
Nothing, Lord.
So how this annexer F has been declared? Because annexer F paragraph by reading correctly,
Yes, Lord. Lord, we'll see that.
Paragraph 9 is related to annexure F.
It's paragraph 615.
Huh?
Paragraph 15.
15. Which paragraph, Mr. Dekka,
15, Lord.
is related to annexure F?
Paragraph 15 in the review, page 10.
Paragraph? One. Oh, oh. One.
Annexure. Nine, page 9, paragraph 14 and 15.
Running
Okay,
page will be
okay,
32, my. So this is a part of
Okay.
it.
Okay.
Running page will be page 32.
Okay.
Page 9 and 10 of the review petition, paragraph 14 to 15.
Paragraph?
14 and 15.
Okay. Okay.
No statement to that effect that there was any mistake committed by the council appearing at that point of he had any misconception of fact. He simply apprised the court that he wants to avail the appropriate remedy, and he availed. The notice was issued subsequently after passing the judgment earlier. But in my humble understanding, Lord, without that statement to that effect, Lord, that the earlier council was under some misconception of fact, or he did make some mistake as regards submission that he wants to avail the appropriate remedy. This petition is not at all maintainable.
Let us kindly come to page 13 of the review petition.
Yeah.
That the petitioner begs to state that the petitioner did not give any instruction to the council representing the petitioner for not placing the said writ petition in order to avail appropriate remedy available to the petitioner under the law. It is an admitted page 13, para 17. On top, page of the review petition. That the petitioner begs to state that the petitioner did not give any instruction to the council representing the petitioner in WPC number so for not placing the said petition in order to avail appropriate remedy available to the petitioner under law. It is an admitted fact that petitioner has already approached the competent authority, that is opposite party number 3 as per tender condition, by written application dated so for redressal of his grievance. Therefore, apparently no question arises for the petitioner to instruct his counsel to withdraw the said writ petition to avail the appropriate remedy. In fact, in the humble submission of the petitioner, the counsel representing the petitioner are in law and fact and in not pressing the writ petition. It is stated that in the process, the cause of act petitioner has been seriously.
Just one question. After passing of the order, immediately within 24 hours, you have reacted. By issuance.
Yes, it is a fact, my lord. We have brought on record, my lord. Otherwise, it will be a suppression of material fact.
Right.
So, my lord, question is that was also in the contemplation, but when the petitioner could realize that actually this is the position, my lord, I am an individual. I am not bound by my any conduct, my lord. I am seeking my remedy. Now, if I come with clean hands, what is wrong in it, my lord? Therefore, my lord, I'm sure, my lord, it's slightly a tricky situation, and I appreciate. But when I could lay my hands to this division bench judgment, where my lord, relying upon the BCCI's case, where misconception of fact and law was also constituted to be a ground of review. And that is what has happened. Nobody is, my lord, so expert, my lord. We are all learning.
No, we are all learning.
Therefore, my lord, it happens. It's not a question of putting blame on anybody. It's a question of, my lord.
Now just for asking in the alternate. Page 89.
Yes.
Under page 89, is there any alternative for you? Just on the
Page
other side.
89. No, my lord, the contract agreement provides this revenue.
Right. Whether it is still open for you
Yes.
or not. In the
Yes.
alternative, I am asking.
No, it is still open for me because now supposing, my lord, when your lordships will hear the matter, that will be my case.
No, as of
As of now, my lord. As of now, my lord, no, my lord, I could have gone in. Let me place our predicament. I cannot go to retail. I don't want to go to suit because I feel, my lord, my remedy lies here. If ultimately on merit,
we have observed in broad terms, because submission was in broad terms.
Yes.
Right?
Right.
It is not specific to suit.
Yes.
In the order whereby this was dismissed on withdrawal. That is why I am asking whether this remedy, say, anything arising out
I think we can still press for it. They're bound to honor their commitment, my lord, under the contract.
whether that is open for you or not.
Yes.
I am just asking for
Yes.
I find it difficult.
Yes.
For
No,
one
my lord,
reason, I am not still applied
The
my judicial
period is over that they are supposed to act within 45 days. That period is over.
Hmm.
If your lordship kindly sees,
No, I am just asking, Mr. Sutri. There are two things. One, this dispute was during the progress of the vote.
Yes.
Right. There is another thing. 89, come to page.
Yes.
89.
Yes.
Third line. Or after the term.
Yes.
I am just asking for the legal point of view.
Of course. After the termination also I can go.
That is what I am. Thereafter something.
In fact, what I was projecting was, my lord,
I am
we
not-
went before termination. Oh yes, after termination.
That is what I am asking.
Ah.
Whether this option, suppose this review
Well,
period.
we approach your lordships after termination.
Ah.
Against the termination.
Right, against the termination. But the petition was disposed of on withdrawal. On withdrawal on the submission of the learned counsel that he will avail appropriate remedy under the law.
Yes.
And it is in broad terms. It was in broad terms, not that only under civil suit. Now, that whether this is open or not.
Should be, my lord. If we give a slightly liberal interpretation, it should be. Because they have not still acted upon it.
Because you have decided not to proceed your petition, suppose.
Yes.
If you want to pursue this after termination, this dispute redressal system, then whether this is.
Then perhaps
I'm asking for your assistance, not
Yes,
your
yes.
submission.
No. My submission would be, my lord, supposing your lordship doesn't entertain my review, supposing, right, then I can certainly maintain a writ petition on this, saying that.
No, you have to raise first.
Raise. I'll raise, then I'll.
Fair enough. Because this withdrawal was in broad term.
Correct.
Because that redressal you sought during the progress, I think.
No, my lord. We approach the court after term.
No. 1 minute.
Yes, after
Yes,
termination
no.
only.
Huh?
Termination.
This was the
Termination is,
termination.
I'll give the dates, my lord.
Okay.
Termination was dated
21
21/8.
21/8.
And we approached on 23/8. My lord, the matter is very simple. The time permitted was 12 months. There was an unprecedented flood. Then they said, you start work. I said, I'll complete it. They asked me to submit my schedule, my lord. Please, my lord, please come to my lord. Page number 53. Recently, my lord, there is a judgment of the Supreme Court where, my lord, everything has been clarified now regarding the power. Page 53. This was the letter written by the executive engineer. Pursuant to this, my lord, I replied at page 54. With reference to the above, this is to bring to your kind notice that on receipt of issue of notice to proceed with the work on 4/5/23, a mobilization work has already started. But simultaneously, due to start of monsoon followed by first wave of flood, now it is impossible to start the actual execution of work as the work site being low-lying area and is now under flood water. Photographs enclosed. Work can be started only after cessation of the flood water. Henceforth, a revised program is submitted herewith for favor of your kind consideration. Now, my lord will kindly come to page 55. Kindly see, my lord. I assured that by May 24, I'll do my work. And that was the timeline as per the contract. I was not even seeking extension of time. Page 55. Proposed work program in months. See the arbitrariness, my lord. Because as per the original contract, it is 12 months and 12 months ends on 31st of May 2024. Still, my lord, that period is there. And I gave a revised work schedule, which they wanted. Instead of honoring their, my lord, commitments, they terminated my contract. Therefore, my humble submission is, my lord, Lordship will pass an appropriate order in the review petition so that, my lord, the petitioner can.
Okay, let me go through the
Yes,
contours,
yes.
Contours of review jurisdiction.
Can I give one more judgment, my lord? Lordship, may kindly take note of that. Everybody knows the judgment. AIR 1963 Supreme Court 1909 TDS.
Year 1963.
Supreme Court 1909. That's the Constitution Bench judgment, my lord.
Name.
Shivdev Singh. That's the first judgment, my lord. And
I don't have the capacity to remember by the years and citation like you. I only go by the name. I don't know. I can't remember the year.
This was the first case when the Honorable Supreme Court said, my lord, the power of review also flows from Article 220, and which is very well. Of course, my lord, it cannot partake the character of an rehead. That situation doesn't arise here. And that Arambam case, my lord, 1979 4 SCC 38. That's a very short judgment, para 3.
1979.
1979 4 SCC 38. As we all para 3. As we all know, my lord, the power flows from section 114 and the procedure and contour is laid down in order 47 rule 1.
I'll go to it. May not be possible to pass today, but why Monday?
I'm deeply.
Paper. Termination was issued on 21A.
Right.
And press tender was issued on 29A.
What is the position?
At that point of time.
No, 29/8/2000,
21A termination, 29A press tender.
What is the position?
My lord, can I indicate, my lord? Not only one, my lord. Until 10/10/23, 4 NITs were issued.
For the same work?
Same work, yes.
What I'm trying to say, Lord, if 21/8 is the termination, 29/8 is the press tender, and the order was passed on 29. Now, if Lordship come to the dispute redressal, Lordship, this is 45 days from the date of arising of the dispute. That is 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of passing the judgment, that remedy was also available to the petitioner. That is, 45 days from 21A. So, on the date of pass of dispute redressal. So instead of this 24, clause 24 of dispute redressal, he preferred the remedy of suit. That is why the notice. So where is the question when he has already used the option law, either 24, clause 24 dispute redressal or the remedy of damages. He used the remedy of damages law. Then where is the question of again granting him the remedy of dispute redressal law at this stage?
Not only damage, actually, you said
Basically,
reallot the work.
My lord,
In a-
my learned friend is confusing with an ATCPC notice and a plain. That is the difficulty.
No, it's fair. 20, he said either allot the work to my client or pay the damage.
Yes.
The lordship in the order,
That's a
lordship,
notice.
it's appropriate remedy. We don't know which is the appropriate remedy for him. For us, only two options are open. Either it is clause 24 of dispute redressal or a suit lordship. He opted for the other.
And what is this additional affidavit about?
My lord,
Anything?
fourth tender was brought on record.
Okay. Nothing has been culminated.
No, my lord. On 21/8 was the termination. We filed the appeal on 23. So therefore, my lord, we are within time. It was on 29, my lord, that the other tender was second tender.
29.
9/8.
No, any of the
Yes, now it
penalty
has been settled.
settled.
Yes. Yes. We have brought on record also. For
It has
that
been-
we could not, perhaps it has. The order was issued on, my lord, 28/12.
28/12.
Yes.
Work
After
order has
filing
been
of the-
issued.
After filing of the review. application.
Work order has been issued.
Yes. Notice to proceed, yes. Work order has.
Twenty-eight.
28, I can hand over one copy. 28, I can 28/12/23. My lord, tomorrow, no, I know where I stand. Question is, my lord, tomorrow if there is a observation of this honorable court, then I go for a suit, that's a different thing. But my lord, as it stood prior to that date, my right has to be recognized.
This is one more.
Dip-
If you Yes, madam.
Sorry about that. As per the last order dated 3/4/2024, Your Lordship, the affidavit has already been filed regarding respondent number.
What is the order about me? And can read it.
Pardon, Your
What is the order about? Contempt case, right?
contempt case, yes.
Now, alleging disobedience of which order? Page,
That it is.
page.
For that page 44 million.
Page 44. Repose the circular
Start from
cancellation of name of the purchaser from the revenue record.
Yes.
For record, name past record. Proceed and proceed. So it was the additional deputy commissioner was asked to proceed with the application for cancellation of patta, right? So when notice was issued, since it was specific to additional deputy commissioner, so notice was issued to
Mr. Vikram Chetri.
Vikram Chetri.
Yes. And
That is opposite response number 3.
yes.
Now thereafter what happened? He submitted an affidavit.
Affidavit stating that during that relevant time period, Your Lordship, this Mr. Vikram Chetri was not in charge of the land records branch. Okay?
Right.
So that is what is being stated in the affidavit. And Your Lordship also, as per the last order, this honorable
So then
instructed
court asked you to obtain instruction who was the concerned
yes,
additional deputy commissioner holding the charge of land record.
yes, that person's name, Your Lordship, I have received the instruction from the DC. It was Sri Ajit Kumar Sharma. So there are several additional deputy commissioners. So maybe the confusion arose there. So, Your Lordship, that is the instruction by the deputy. Let me kindly repeat the name of respondent number 3 and
My lord, then we may be allowed to implement, my lord,
That's all.
new
You
income.
make the application to delete the name of this man and delete this man.
My lord, let us have a copy of this.
I'm recording in the order.
My lord.
In the order itself, I'm recording.
My
Third, Mr. P.K. Sen, Learned Council for Application, and MS, and Board of the Learned Standing Council. Learned
Your
Council.
Lordship, I'm
Order
appearing-
response number 3.
I'm appearing for respondent number 3.
Response number 3.
What is that?
Comma. He becomes it. MS Board who was asked to obtain instruction from the office of the Deputy Commissioner Company Metro 1 on the previous date of 15, 3/4/2006 as to apprise the court as regards the officer, concerned officer, who was holding the post of additional deputy commissioner and in charge of land record branch on 30,020 MS board by placing communication bearing number 24 dated. Noted. Bearing number 20. Of the Deputy District Commissioner, Kamrup Metropolitan 1, address her, has submitted that 1 Sri Ajit Kumar Sharma, SKS, additional district commissioner, Kamrup Metro District, was in charge of the land record branch in the office of the district commissioner, Kamrup Metro District on 13/6. In view of the above information, Mr. Sen has got 1 week time to file appropriate bidding.
To implement
Appropriate bidding
new the
seeking
present
implement of necessary concerned respondent and for deletion of the name of the respondent in the count whose presence is not found. So,
Right.
as paid for by
What may kindly take that
record.
bill?
obliged.
And then when you file, it will be listed.
Let us see.